Sorry.
Yes, repetition is allowed. The order of appointment of respondent number 5 as postgraduate teacher in physics in Demo Higher Secondary School is set aside. Consequent direction is issued to appoint the petitioner in place of the respondent number 5. Principle of no work, no pay is applied, but the petitioner would be entitled to notional benefit, including seniority, on the date when respondent number 5 was appointed. There's some corrections, we'll get it after some time. In the meantime, you can see it, but there's some corrections. Yes,
My lord, name mention item number 56, my lord.
or any prayer for listening, please give it to the court master.
Item 56, my lord, today we are filing the affidavit as well as application for vacation of the interim order. So, other side is there, my lord. They want it on 24th, 518, they want 24th. July,
24th of July.
right. 24th or 25th, my lord. 25th, my lord.
We get 25th. This will take some time.
My lord.
Item number, item
56.
56.
Quite good.
Mr. G. N. Savalan and Senior Counsel,
Appealing for responding.
appealing for respondents.
Along with an annexing, my lord.
Instructed by Mr. N. Singh, counsel for the petitioner, respondent, submits that affidavit in opposition is being filed in course of the day, along with an application for vacating of stay. First off, Mr. K. Kavital and the counsel for the petitioner is present. Respondent is granted time to go through the same and respond if so advised. As agreed to by both sides, list on 24, 25, 7/2023.
Time may continue.
Okay, intimate of past this times extended till next date of this thing.
Obliged.
I beg to mention item number 14, which one with consent of the other side.
14.
14. Today morning, we have received the brief with NOC from the earlier state of advocate. Matter may be taken upon the after tomorrow. Urgency also they are in this.
Okay, list on 28, 6/20 is paid for by Mr. A.V.T. Hockland, counsel for the petitioner. You have a petitioner,
I am for the petitioner, lordship, just to hear file look not normal lordship.
just a moment. Forrest, you were there.
Lordship, I have taken consent as the lordship. There are.
PN Goswami appears.
P.M. Goswami was
Yes, sir.
appearing.
Or K Pathak.
In fact, in this case, we have already issued a notice. I think no interim would be required. Some order has been passed yesterday.
In this case, I've filed an IA for implement the petition as a petition number 2 in this case.
No, it-
9 February 9. Resolution. Resolution to put to the
in the periphery area of the Dibru Saigua card.
Yes, lordship.
Okay, day after tomorrow. Okay. It's okay. List Oh,
along with
so,
the IA.
I don't know.
along with the interlocutory application number,
Not number three, it could be IA file.
IA number, IA, if any, filed by responding number,
Petition number two, implemented as petitioner number two.
petitioner number,
He has filed a implement petition as a implementing petitioner number 2. He has no locus lordship. With
Petitioner,
object
how can
action
you-
here. He cannot file as
no, no,
such.
you can't do it.
He cannot
No,
file.
no,
as
my
such.
lord, earlier the petitioner, the.
No, no, whatever, you
Fine.
can't join somebody's, read petition and then make your own case.
No, no, my lord, what happened, my lord? the
No, no, whatever it happens,
committee-
let it come, but it will not be permitted. It can't be permitted. Two set of counsel for petitioners can't make their submissions. It can't be made by you, along with the interrogative applications. While they, filing the matter. Okay.
Oblige you.
Fair play, Lordship.
At least, I have not seen any. At least I have not seen, Mr. Sayola has more experience. Can two people, different set of people sit as petitioner and argue? I have not seen in my limited experience.
That can't. That can't.
No, I'm just
Either
verifying
one-
because I have
either
not seen that. Huh?
Either one, even senior may allow the junior to argue.
No, that is different, but
He
two
cannot
sets,
find
in
a
my
set.
experience,
No, that's-
no, because I have lesser experience than you, that's why I'm asking. Okay, yes,
Please, your lordship.
Yeah.
Lordship, with regards to item number 27 and 28, my lord,
yes,
both the matters have become infructuous, my lord. The NIT was till March 2022, my lord.
27, 28.
27 and 28, my lord.
Okay,
29 and 30 also.
okay, 28, Mr. P.K. Bordole,
Okay, Bordole.
Mr. P.K. Bordole, upon instructions, has submitted that by effects of time, the matter has become infructuous. The learned government advocate, will be there,
My
Mr.
lord,
Time, please, for
Sharia learned government advocate and
She's for the JMD.
Ms.
our
R.
dates.
Deca, learned counsel for Jorhat Municipal would represent. Matters was dismissed on having been rendered infructuous. And in this item 29,
29,
30,
29, 30.
Mr. D. Chaudhary for the petitioner. Same. Okay,
Hello.
Mayor, Pray, Lordship.
yes,
Lordship, in a connect, in a repetition we had filed.
Hmm.
Lordship, we had sought the transport subsidy scheme.
Hmm.
Lordship, we had made certain claims, and their claims were not being considered, it was rejected, right? Lordship, the notice was issued in the repetition way back in year 22, the matter has not been listed thereafter. Now, Lordship, the department has come up with a notification fixing a deadline till July 2023, saying that if the claims of any persons are not placed before the committee before July, then the claims will never be entertained, will no longer be entertained. Lordship, may I pray for listing of this IA for interim order, Lordship? On Wednesday, Lordship? All right, Lordship.
Religious item number 1 motion.
Lordship, before my senior start, Lordship, some protection has been given on white order dated 24/23. That may be extended and matter may be fixed after vacation, Lordship, so because I want some instruction from the authority, Lordship. So not direct, but indirect, some protection has been given, Lordship. Because matter will need some deliberation, Lordship. Whether the writ is also maintainable, that question will also be decided, Lordship.
No, but I don't think there was a stay granted.
No, I ensured that no further proceeding will be pursued before the arbitrator. Lordship.
Then I'll put down in the order, otherwise it will be difficult.
Yes, that will be better, my lord. Well, because the general manager insisted, my lord, the deputy manager, to proceed with the arbitration in spite of the pendency of the case.
No,
And
Lordship, I
now
will
the
communicate.
arbitral
Lordship.
tribunal has passed.
No, once he's considering.
The moment the interim order is passed, Lordship, that will be, it can be disposed of in the next day.
Yes, interim order may be passed, my lord, and it may be fixed for it.
Not admission, let it be in the, on a, no.
No.
Non-miscellaneous day, Lordship, Lordship.
Take it up, but not in motion, because
yes.
there's some difficulty in
Motion.
handling. I have a very bad habit of at least looking through the papers before coming. Admission, I can take some rest.
Yes.
But Mr. G. N. Savada, the senior counsel, assisted by Mr. D. Sanapati, the counsel for the petitioner, and Mr. B. Chakravarti, the standing counsel for the, sorry, CGC appearing for the respondents. Next for that. The learned standing counsel for the respondents has submitted that he needs some additional information and instruction. To effectively make his submissions, And accordingly, prayer for adjournment has been made. Next paragraph. Having regard to the nature of dispute raised in this presented petition, let a formal notice returnable on, take a date when
28th of July, my lord, 28.
28. Okay, 28/7/2023. You need extra copies also?
No, yeah, affidavit has been filed and rejoinder has also been filed, Lordship,
Oh, okay.
in this case, Lordship.
Without requiring the petitioner to take any steps, as readings have already been exchanged. Next paragraph. Having regard to the nature of dispute, it is provided that till the next date of listing, the arbitration proceedings shall be kept in abeyance. Post of the extension of the interim order will be subject to further orders that may be passed on the next date. List on 28.
Lordship, only one observation, endeavor may be made on the next day.
We'll make it, if we are there, we'll make it, but I don't want to report that.
Once Lordship, interim order, that will go cause difficulty, Lordship.
No. You just remind me of this arbitration matter on that day. If I'm there, I'll recollect and.
Wait, please, Lordship. In this case, Lordship, we have filed an additional affidavit, Lordship,
Where is that?
and to bring into record
Tender documents.
minutes of the meeting of
The tender document itself is not there.
Lordship.
Tender document, is it there? I did not find it.
The additional affidavit, there is a document, Lordship.
Okay, additional document, it's not there. When did you file it? It's not available. When did you file it?
25, Lordship.
25. Okay. Mr. R. Fukan, the counsel for the petitioner, submits that an additional affidavit is been filed to bring additional documents on record. Mr. M. Chetia, government advocate, is present. Next, list on day after tomorrow. List on 28/6/2023, along with the additional affidavit filed by the petitioner.
Obliged,
Just check up if there is any defect or not.
Lordship, obliged.
But you filed on 25, you said. When did you file it?
20th of May.
20.
Lordship,
Filed on 25/2023.
obliged.
Okay. Yes,
May I please, your lordship?
yes.
My lord, the petitioner
while working as an inspector of Assam Police, had been posted as the chief drill instructor.
But you can't be permitted to stay in the government quarter.
No, my lord, I am not for the, my lord, indefinite period I want to stay, my lord, at least.
For 1 year.
No, my lord, I made a representation for 1 year, my lord, that is.
No,
correct,
no, but that's
some-
not permissible.
my lord, but some, because.
No, you see, once
my-
you, armed, what do you call this, enclosure for this battalion,
My lord,
that will not be available to a, what do you call, to a non-combatant. Because after you have been dismissed,
my lord.
you are a civilian. You can't be
I-
permitted to stay in the police quarters, which is otherwise a protected
my lord,
area.
I will arrange my alternate accommodation till my arrangement, my lord, at least on, because my lord, my appeal. Before the appellate authority till date is pending, my lord.
No,
My lord,
you have to go to Magic Bricks.
my lord, my lord, on humanitarian ground.
No,
they
no,
can for 1
because
month.
no, this is a
Well-
sensitive area.
Mm.
This enclosure itself is a sensitive area. Police quarters, you can't stay if you are not a combatant.
The
Uh,
area where I am residing, my lord, is just not in the, within the zone of training, my lord. It is somewhere the outskirts, my lord.
You've seen today's back newspaper.
My lord.
There's an article, news article referring to one judgment of one court
My lord.
where allegation of sexual assault was made by a girl.
My lord.
And the court did not entertain because the place was a cantonment area.
Yes,
And therefore it said it's not possible because it is encircled by army. So therefore, in the cantonment area, that's not possible. So you see, that view, extreme view can also be taken.
my lord. I can, my lord, the allegation against the petitioner, my lord, is not so good, my lord. I can.
No, whatever
understand,
be, but whatever
But
be,
that
but,
is under examination that whether I have
but
committed. or
you'll
not.
have to, once you are reinstated, you will get back your quarters,
My lord,
but not now. You'll have to make alternative arrangements.
my lord, at least for 2 days, my lord, if till I can make the arrangement, my lord.
Even my lord, from the first notice, he has got sufficient time, my lord. First notice was served on 14/10/2022.
My lord.
Okay, we'll give you 1 month to make
Yeah,
arrangements.
yes.
My lord.
1 month will be,
Yes, my lord, within 1 month I will make, my lord.
by 31st July, you'll vacate.
My lord.
Mr. A.R. Bhuyal, I'm a counsel for the petitioner. And Mr. M. Chetia, I'm a government advocate appearing for the respondents. If you notice a motion returnable on 24/7/2023, requisite extra copies of the representation is served on the Government State and Departmental Council in course of the day. Next, Lord. Heard both sides on the prayer for interim relief. The petitioner was at the relevant point of time posted as chief drill DRILL instructor at the Armed Police Training Center, Dergaon, was accused of sexual harassment and
Terminate.
after departmental inquiry, the service of the petitioner was terminated. Full stop. Although the petitioner was served notice to vacate. The notice is dated 14/10/2022, 2/4/2023 and 25/4/2023 to vacate government family quarters, he has not complied with the same, inter alia, on the ground that an appeal is pending.
My.
Full stop. And in the representation, the petitioner is seeking 1 year's time to vacate. Full stop. Considering that a reasonable time be given to the petitioner to vacate the government family quarter. The court is of the opinion that with the status of the petitioner as a civilian, he would have to make alternative arrangement to vacate the government family quarter within 31/7/2023. According to the according as an interim measure until the next written date, it is provided that if the petitioner gives an undertaking before the the head is commandant of
Milord,
this
the
training
notice has
center.
been issued by the Milord, commandant.
Commandant, my lord.
No, who is the head of this armed forces training center?
Lord, he is the commandant, Milord.
Commandant, okay.
Battalion Training Center, their ground.
Okay. In the event the petitioner gives an undertaking before the undertaking in writing before the commandant, battalion training center, Dergaon, within bracket respondent number 4, he will be permitted to overstay the government family quarter till 31/7/2023. So it is made clear that if such a written undertaking is not submitted, the petitioner would not be entitled to the benefit of this interim order listed on 24/7/2023.
Obliged.
Or
You produce the certified copy before him, respondent 4.
My lord.
Petitioner shall produce a certified copy of this order before respondent 4 to bring the order to the notice of the said authority. Yes, item 4.
Obliged.
May I please, Lord?
Yes,
My lord, my lord, settlement, lordship kindly see at page, my lord, 33.
yes,
Lordship will find, my lord, time period, my lord, lease period, 29/4/2023 to 36/2023.
yes.
This is the period. Because of the earlier proceeding, my lord, this settlement has been made. Now, lordship kindly see the page 35. Page 35.
Yes,
Yes. Page 35, my lord, first paragraph, my lord, second line. It is strictly prohibited to catch fish in any proclaimed water bodies during the ban period with effect from 1st April to 15 July.
yes.
Now settlement is made on 29/4/2023. After the settlement, my lord, not a single day he was allowed to catch the fish.
The only remedy you have is to pay for remission.
Yes, that is the only remedy, my lord. And for that, my lord, lordship will find, my lord, at page, my lord, 58.
It's okay,
Yes.
who is the authority to decide the state?
Government.
State, my lord.
Which authority?
Principal Secretary.
Principal Secretary.
Page 58, lordship will find. Page 58. It was filed on, my lord,
36.
13/6/2023.
So within 15 days, even I can't respond so fast.
Because the settlement would be made on 1st of July.
No, that is okay. Considering that I work in the courtroom, I work from 10 to 7. Even I will not get time to dispose of representation of 13/6/2023. Okay, but consider it
My lord,
within a month.
my lord.
Now, one
After
thing more,
receiving
my lord,
the
may I submit,
certificate.
my lord, the NIT lordship has seen, this is in violation of Rule 47 of the Assam Panchayat Financial Rules 2002.
How?
Because 47 says, my lord, it has to be floated, my lord, before 45 days. Rule 47(2).
It's okay, they will reduce the, what you call the tenure.
Yes.
That is
Now,
not that challenge.
only my lord, prayer, my lord, till my lord, consideration of my remission prayer, my
No,
lord,
no, no, absolutely not.
that, my lord, that particular, my lord, preliminary bill may not be, my lord.
No,
granted.
no, we are not interfering with bids.
If it is settled, my lord, how he will be, my lord, benefited by your remission.
No, you can be broad-hearted, waive the remission also.
I leave it to your lords.
You've seen in Russia,
Well.
broad-hearted man tried to capture Russia and then went away. So even countries, people live like that. Heard Mr. M. Mandal, counsel for the petitioner. Ms.
For all the
Mr. M.
responses.
Chetial, and
I'm bringing
Yes, sir.
for all the responses.
okay, Mr. S. Dattal, and it's standing counsel for the Panchayat and Rural Development Department, appearing for the respondents. Next one. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has challenged the legality of NIT dated 35/2023 issued by the Agomoni AGOMONI Anchalik Panchayat under Dhubri Zilla Parishad on two grounds. Firstly, that the petitioner was settled with balance settlement period of 29/4/2023 TO2 36/2023. First of however, by virtue of notification is by the which page was that?
Yes,
Notification?
35.
35.
Notification dated, my lord, 3/5/2023.
Okay, 3/5/2023. There was a total ban on fishing activity from 1/4/2023 to 15/7/2023. And according to the petitioner, could not enjoy the limited settlement period of the said fishery. Yes, sir. Secondly, it is projected that the tender was not floated 45 days prior to the period of settlement, which is in violation of Rule 47 within bracket 2 and 49 of the Assam Panchayat Rules, 2002. Hence, it is submitted that till the respondent consider the prayer of the petitioner for extension of lease period or for remission, the tender process is liable to be stayed. And hence this petition under Article 226 of the Constitution of India. Next one. Upon hearing the learned counsel of the petitioner as well as the standing counsel for the PNRD department, the court is of the constituted opinion that as the petitioner could not undertake fishing activity during his lease period of 29/4/2023 to 36/2023, owing to ban on fishing activities purportedly by order dated P5/2023 by the Managing Director, Assam Fisheries Development Corporation Limited. The petitioner has a right to move the authorities for remission of his of the case money deposited for the said period. Next paragraph. Moreover, if there has been a violation of Rule 47 within bracket 2 and 49 of the Assam Panchayat Rules, 2002, it is expected that the authorities of the Panchayat and Rural Development Department shall structure the fishery settlement for the actual period by excluding 45 days from the date of floating of the tender. 45 days will have to be gaps. So accordingly, the respondent authorities shall consider the actual period that is legally available for the fishery, taking into account the provisions of Rule 47 within bracket 2 and 49 of the Assam Panchayat Rules, 2002. Next, nonetheless, on both the counts, no case has been made out for interference of the court under Article 226 of the Constitution of India, as the petitioner has an alternative remedy of applying before the competent authority in the government, i.e. the Principal Secretary, PNRD, Assam, consider prayer for remission for not being able to enjoy the fishery due to the ban in fishing activities by hearing before referred order dated 3/5/2023. P5/2023. Even on violation of the Rule 47(2) and 49 of the Assam Panchayat Rules, 2002, as the period of fishery can be regulated, no case is made out for interference by the Red Court. First of all, a court does not find the tender process to be initiated only on those two counts alone. Accordingly, the court is disinclined to entertain this writ petition as to how liberty is granted to the petitioner to. You have filed a representation where?
Yes.
Where is that?
Yes, 58.
58. As the petitioner has already submitted his representation, dated 13/6/2023, before the Principal Secretary, Government of Assam, PNRD Department, the State Authority, is directed to dispose of the representation of the said representation of the petitioner within an outer period of 4 weeks from the date of receipt of certified copy of the order. With the aforesaid observation, this petition stands closed.
Sorry, my lord, for respondent number one, my lord, my colleague will appear, my lord.
One, you will be appearing,
Yes,
MJT,
rest time.
respondent open.
I'll oblige.
Made visible.
Please wait. Mr. Kiali is not there. Please wait for some time. You're there?
Lord, so I want behalf of Mr. Ethnic Journalism League, so that's something.
It's
This case, Lordship, the petitioner was arrested, treating him as an intermediary of the circle office.
I'll issue a notice.
So there is an judgment allowing similar case, Lordship. It is a case.
No, not without hearing them, not at motion stage. Not at motion stage. Let them say what they want to say.
Okay.
Mr. R. Sharma, counsel for the petitioner. And Mr. M. Sethi, and government advocate appearing for the respondents,
1, 2, 3, and 4, my lord.
1 to 4.
1
Okay.
to 4, my lord.
By filing this replication on Article 226 of the Constitution of India, the petitioner is assailed. The notice issued by respondent number 4, i.e. Additional Superintendent of Police within bracket headquarters, bracket closed, Vishwanath, to freeze the operation of the to the respondent numbers 5 and 6 to freeze the operation of the bank account of the petitioner. As this revision or Article 26 of the Constitution of India. You shall notice a motion written on the line. 4 weeks, because the extra copies of the revision is certain of the United State. Government advocate for respondent numbers 1 to 5, 1 to 4. Petitioner shall take steps within 2 days for service of notice on respondent numbers 5 and 6 by registered post with AD. Next paragraph, the counsel of the petitioner is permitted to correct possibility number, possible track report. Just say one thing, notice including notice in the prayer for interim relief.
seven,
Well, 7, 8, and 9, well, identical laws. We
Same,
have
same,
already
okay.
decided.
Okay.
Here, my lord, only my lord, private party is not there.
Private party is not there. Okay, just not, private party is not there. Is standing bundle for the petitioner and Chettiar and government advocate appearing for respondent number
1, 3, 4, and 5, my lord.
1, 3, 4, and 5. And for number 2, Ms. V. Hazarika. Same order. This Khatya number is same 82.
Yes. My lord, here, Khatya number is 76. my lord.
In all 3. Just make this correction in this order.
Yes.
Mr. Mandal,
76.
in all 3,
Yes, my lord, all 3 76.
70,
76.
76.
76.
Dated
Later, my lord, 2 to 61.
2 to 61. Okay, same thing.
Leave notice.
7, 8, 9.
10,
Please, your lordship. Lordship, I have received the payment from the
You
concerned
receive.
committee.
Okay. Your name
Emil
is
Konyak.
MN Konyak.
Hearing on behalf of G. Chaudhary.
Then the counsel for the petitioner. And Miss
S. Bara on behalf of MD Bara.
as Bora and the council appearing on behalf of Ms. M D Bora, counsel for the Transport Department. Next, upon instructions, the Government Council for the petitioner has submitted that in in the meanwhile, the payment due to the petitioner has been received, and therefore she has instructions not to press the matter. Accordingly, matters is the dismiss is not pressed.
Yes.
11,
Lordship,
Yes, item 11.
maybe after some time. Your Lordship.
Okay.
12,
Make legal action. Lordship, this matter will be passed over for the time being. Lordship, Mr. Armageddon will be legless. It's coming.
Who is for this, what you call, food and civil supplies will be appearing. And for BTC, you are appearing. So what is it, why these rate petitions are coming up? Why you are not providing that POS system?
Proposal already submitted from BTC side.
Proposal is submitted. Then you are issuing a notice.
Yes, sir.
Lordship, let him come.
Who?
Mr. Armageddon leading. He's
Yes,
coming.
we will issue a notice. Because we are not giving an interim order except that your service will not be discontinued.
Lordship.
Okay, Mr. Islam Council for the petitioner. Mr. M. Chetial and government advocate appearing for the respondent numbers
1, 2, 3, and 4, madam.
1, 2, 3, and 4,
4 and 7, madam.
1, 2, 3, 4, and 7. And Mr. Musari,
5 and 6.
R. K. Musari,
5 and
done as standing council for respondent numbers 5 and
6.
6. Petitioners. Next. Fella. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the retribution is served on the state and department council in course of the day. Next paragraph. For both sides on the prayer for interim relief. Next paragraph. As the petitioner has already applied for issuance of appropriate identity as well as small e, capital POS facility for distribution of food articles. Before the competent authorities, it is provided that the respondents shall not discontinue the fair price shop of the petitioners without till the next date of listing. Just prior to that, you write ID as well as the EPOS. And further considering the submissions made by the London Standing Council for the BTC, that proposal for providing such facilities have already been sent to the appropriate authorities in the government. Then
On 25 April 2022.
it's okay, I've recorded the
18
statement.
also same, madam.
Huh?
18, item 18.
Yes, I can.
18 is same,
Same.
same one.
Bless.
13,
Yes, this PMA house,
Yes, Lord. Yeah, I'm after so.
yesterday I passed an order.
Yes, sir. Yes, yes, sir.
You remember the case, not yesterday, the last working day, Friday, you remember the case number? Okay, your name,
Yes, Islam, your lordship. I'm
Yes,
getting
Islam.
on behalf of Ali, your lordship.
Learned Council appearing on behalf of the Learned Council of the petitioner on record. Also heard Mr. S. Datta, Standing Council for PNRD Department appearing for respondent numbers
1, 2, 3, 4, and 5.
1 to 5. Next one. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the retention is served on the Honorable State and Department Council in course of the day. Petitioner shall take steps within 2 days for service of notice on private respondent numbers 6 to
8
8
euros.
by registered post with ED. The postal receipt track report. Next paragraph. Having regard to the projection in this writ petition that money was sanctioned for construction of the house of the petitioner, namely Hamida Begum, HAMIDA Begum, alias Hamida Khatun, under PMAY ID number AS 1567976. And it is claimed that no money was ever disbursed to the petitioner. But the online status of the construction is shown to be completed. The respondents in the PNRD department are directed to file their affidavit in opposition positively on the next date of listing. So it is made clear that if affidavit in opposition is not filed, the court would be compelled to pass appropriate orders on the next date to call for personal appearance of the respondent numbers 1 to 4, 1 to 5 with relevant records. Next paragraph. The petitioner shall produce a certified copy of this order before the respondent number 4. Bring the order to the notice of the said authority. In the meanwhile, the learned standing counsel for the PNRD shall also send a downloaded copy of this order to the respondent numbers 1 to 5. Next paragraph, at least after 4 weeks. Next paragraph is so okay. Yes.
The petitioners, my lord, amount is from the bank, my lord, has been withdrawn by some fraudster, my lord, without any information. And that was done, my lord, during the period 2026 to 2020, my lord, and 26/9, my lord.
26/9/2020.
Immediately, the petitioner is lodged in FIR, page 25, my lord.
No, but you see, in this case,
Yes. And complaint was
The-
lodged.
the finding of the ombudsman is that you have compromised the what do you call this?
Well, that is
passwords
their,
and all.
that is their allegation, my lord. No such, my lord, compromise was made with my the credentials and the OTPs, my lord. To
No,
the
because you
court
see
staff,
now in the writ court,
my lord.
how can I show anything? This what do you call before the proceedings before the ombudsman,
Yes,
this this mobile phones and all, they were not sent for examination because whether the whether SMS was received by you, whereas there is a specific finding that the authorities had disclosed that the SMS and email alerts were sent.
but in fact, that was not received by the petitioner, my lord. Lordship kindly bears the,
No, but
their,
you see, how can that be decided now in the red court after 3 years?
well, since police case is pending, my lord, the petitioner has waited for the final result, my lord. But there is no result forthcoming, my lord. And the notification, their Reserve Bank of India's notification.
No,
page
Mr.
20
Saiya, you see, you show me a way, how can a red court arrive at a finding of fact?
Well, there are other cases already disposed. My lord, Justice B. J. Agola's case is also disposed of by the Honorable Court, my lord, on this particular point. Page 33 of the guidelines of the Reserve Bank, my lord.
Page,
Page 33. Relevant portion you also will find page 38. How bank is liable.
now you,
Page 38,
page 38.
clause 12, my burden of proof. Clause 12.
Where is that finding of the ombudsman? Where is that?
So it's page 30.
One.
Yes.
You come to paragraph 5. You see there are as many as 8 reasons assigned.
Yes.
In this order. First is that SMS were delivered to the customer real time.
It is their version, my lord.
No. Please refer to attachment SMS logs.
My lord.
Therefore, these documents are there.
It is their version, but I have not received any information, my lord.
No, but
Had I been received notice, my lord.
where it says, you read that page 31,
Yes,
there is a specific amendment made in this order.
yes. That is
That-
there, my lord. I
No,
am
no.
not denying that. That is there.
So therefore, you have not challenged that finding.
My lord, since I have not received any information, that is my case, my lord. The moment I received the
no.
information, I lost in FIR,
No, you see, the logs were provided to the ombudsman.
my lord.
At that point of time also, you did not raise any objection.
Right.
It's not recorded in the order. I have not found anything where you have denied it. Because here, you see, that is number 1. Correct.
It's all afterthought, my lord. They have made
No,
it,
no.
my lord, just to deny the benefit.
No, it's okay, afterthought. Let us accept it, your version.
Right.
It is afterthought. Okay. But these logs were available. Have you denied that in the before the ombudsman? They were not denied.
No, my lord.
Yeah.
That is not-
So it is an admitted fact. Now you want to challenge that fact without making any allegations
Since the
in the
FIR,
petition.
FIR has been lost, my lord, and investigation is on, my lord. Bank has not
No,
filed
it's-
any case, my
No,
lord.
it's okay. You see, if I say that I don't see you,
Right.
correct?
Right.
So now you are standing in front of me.
Right.
I am saying that I have not seen it. I am not seeing Mr. Segia. Now, how is this to be resolved?
My lord, the guideline says, my lord, it is the bank's duty, my lord.
So they have
Bank has
done it.
not filed any FIR, my lord. That is the important point.
No, why they will file it?
The moment
If
I
I am not
inform,
aggrieved, why should I file an FIR?
the moment I inform the bank should have filed an FIR before the
No,
authority, my lord.
No, you are the aggrieved person. Why will the bank?
I had filed, my lord, but on the part of the bank, there is no FIR, my lord.
No, but you see, please refer to the attached SMS logs. That means those logs were available. That is number 1.
Right.
Second is, you claim that the transactions were made on 7/6, 8/6, and 9/6.
Yes.
You reported to the bank on 24/6 after 15 days.
Since that, in that period of time, no information was received by me, my lord. I am a assistant professor, my lord. I am
Then,
not a layman, my lord. The moment I get the information, I have lost the information, FIR, my lord, as well as the complaint before the bank, my lord. And the guideline, my lord, clause
No, the
12 says,
bank-
but it is the bank's
the
liability.
bank gave you an email of November 3, 2020. You did not respond to it. You have been provided with the details of the 5 banks from where this were made.
My lord, exactly this point has been, my lord, discussed in the case of my lord Justice P.J. Agarwal. I'll place
Show me that.
records, my lord. I'll place, my lord.
Okay.
I'll fix a date, my lord.
Because you see, that is what is happening is payments are made through UPI,
My lord.
correct? And in UPI transactions, these OTPs are not generated. And therefore, nobody compels anyone to use the API mode for payment,
That's true, my lord.
correct? But now supposing I use this, what you call this UPI payment for making payment of, say, what you call any item. I want to eat a tamul, I am paying it through
Yeah.
UPI.
Yeah.
So therefore, I am compromising the,
Why should I compromise? That is the problem. Why should I compromise, my lord? To the
No,
fraudster,
because you see.
to
the-
siphon an amount of more than
it-
12
it's
lakhs
not
and
a-
50,000.
It's not as, it's not a transaction which is secured by the bank.
Yes, my lord.
UPI payment.
That is the fault of the bank, my lord.
No, UPI is a third party. The bank doesn't take a liability. You show me one document which says that UPI payment, the bank takes a liability. You show me one document.
My lord, so. This is Vidyagola's case is totally. Covers my case.
Mr. P. J. Sikha, counsel for the petitioner. Let a notice of motion written within 4 weeks be issued. Requisite extra copies of the petition be served on the, sorry. Petitioner shall take steps for service of notice on the respondents by registered post with AD. Or you'll be appearing for respondent number 4. Mr. M. Setia, government advocate for respondent number 4. Extra copies in course of the day. States by registered post with AD 1, 2, and 3. Postal receipt, postal track report. Next, list after 4 weeks.
Lovely.
16,
In this case, the petitioner is a registered class 1C contractor. And pursuant to a bidding process, your lordship, he was issued the preliminary offer of work by way of work order dated 24/5/2023 at page number 13. Page 13 is the work order issued on 24/5/2023. With the condition
Oh,
that
we'll have to issue a notice. This has to be stayed.
No, my lord, kindly see page 13, my lord.
I've seen that.
Page 13, my lord, and my lord will come to page number 16, my lord. 16, my lord, see, this is a FD receipt, my lord.
16.
And 16, my lord, they have not marked this page also. It's annexure 3. My lord, see, it is written, my lord, as by hand.
It's
Where-
okay.
My lord, no, where is the communication that you have accepted? Merely, my lord, giving that to a FDR receipt in his own name and inscribing by hand, my lord, it doesn't mean, my lord, security deposit has been deposited, my lord. In an instrument, it has to be written, lien has to be said, my lord, who is the beneficiary on, in case something happens, my lord, where to go, if this is enforceable, my lord, see just written by hand. There has to be a forwarding letter and tune of page 13, my lord. It says you have to communicate your acceptance. Where's that
13.
letter, my lord?
13.
13, my lord. 13, my lord, see. Dear sir, with reference to so and so, you are hereby requested to inform our willingness to
Where,
work.
where is that? Where is that?
My lord, it starts from dear sir.
Yes.
With reference to the above, I am directed to inform that the work of implementation of so and so is offered to the approved as per so and so. You are hereby requested to inform your willingness to work at the approved rates by submitting an acceptance to this offer in the form of performance guarantee at the rate of 5% of so and so in below form of FDR/TDR/bank guarantee within 15 days. Well, where is the communication? Just writing, just giving a
It's okay.
Xerox.
No. This, how much is 5% of?
Exactly, my lord.
89?
If he had, my lord, gone.
It is
resolved
given
that
No,
before.
it's not believable that somebody will get a 5,49,000 FDR
My lord,
and they will not communicate it to you.
my lord, yes.
People get below details of the scheme.
No, but
estimated
there has
cost,
to be one communication that
And
this
then
is the amount, this
approximate
is the
total value.
5%.
Lordship has got it at page number 13.
Where is the
You see,
communication, my lord?
This
Acceptance,
is 446. Correct.
my lord.
Amount is of 4,46,000. 4,46,000. and then,
Amount is, my lord, here it is written 5,49,000,
No, that is matured value,
my lord.
maturity value,
It's 446, my lord.
446. So 100% would be,
No, it is
Uh,
given at page 13, your lordship, amount.
No, my lord, this
Page
document
13
is not
itself, your
isolated, my lord.
huh?
Page 13, your lordship will see details of the scheme is given and then given approximate total value of the work. 89% performance guarantee amount is 4,45,000. He was supposed to give, but he has given 4,46,000. Lordship has got it.
Yes.
But just figure match, my lord. But where is the communication that this is the 5% I have accepted? Where is the acceptance? And my lord will also notice that normally in course of bank transactions, my lord, we do not inscribe like this, my lord. There has to be a forwarding. Suppose my lord, I issue a FDR in his name tomorrow, there has to be a forwarding that he is the beneficiary, my lord. Can I write like this, my lord, in a bank instrument? And if it's Xerox, my lord, it is still in his custody, my lord. If it is my lord Xerox
No, no,
here,
no,
it is
no,
in
no.
his still custody, my lord.
No, no. I give any document to anyone, I keep a Xerox.
That's a different, my lord, is vigilant. But my lord, this is not the way, my lord. There has to be a letter, my lord, that he has accepted. Where is that acceptance letter? Let him produce that. Then my lord will consider, my lord, interim. Page 13 specifically, my lord, is a twofold, my lord, that there has to be a communication.
Nay, sir.
And also bottom part, my lord, this it's provisional, purely provisional.
Yes, sir.
Lordship, there
Yes,
is,
sir.
the condition is that he has to accept the offer by submitting a performance guarantee. There is no such thing that a letter should be. Lordship, I will read again. With reference to the above, I am directed to inform that the work for implementation of Kallasanpara New Pipe Water Supply Scheme under the program Jal Jeevan Mission Assam is offered to you at the approved rates as per RFP number 30 package 3 of 2021. You are hereby requested to inform your willingness to work at the approved rates by submitting an acceptance to this offer in the form of performance guarantee at the rate of 5% of the effort value of works indicated below in the form of FDR, TDR, bank guarantee within 15 days from the issue of this offer of pledge in favor of so-and-so. So his acceptance of offer should be in the form of an FDR of the value that is indicated, your lordship. It is not that it should be accompanied by a letter or something like this, your lordship. Or otherwise also I have already deposited, your lordship, and
No, my lord, he's put a strict proof out there, my lord, because in the form.
No, no, he will definitely do it. The next day till next day, you don't proceed with the retendering.
My lord, this is a well, JJM is a, my lord, it's a time frame, my lord. There's a, if it is not executed in a time frame, my lord, whole goes, my lord. And my lord, he also has to produce, my lord.
It's okay.
Yes, sir.
If you want, the day before, what you call, day after tomorrow, you file an affidavit saying that it has not been deposited.
And that apart, my lord, has this document any endorsement from the PHE, my lord? This document at page my lord 16. Has it any endorsement? It has no endorsement,
No, no, you see, that is for the authorities to tell us
my lord.
that they have not received it. Let them file an affidavit by day after tomorrow.
My lord, day after tomorrow, I'll come in instruction, my lord. My lord, consider, my lord, stay, my lord, till only day after tomorrow, my lord. Not today, my lord. This is not the manner, my lord, because tomorrow I can also go and file anything and write upon it, my lord, and seek instruction.
No, sir,
Take my lord, stay, my lord.
Nobody is foolish enough to get a FD of 4,45,000 and keep it in his sleeve. Nobody will do it.
Exactly, my lord. Where is the
Nobody will do it.
endorsement, my lord,
No,
that
no.
it is within our custody? That it is
No,
written
it's
to
okay.
us, my lord. There has
It's
been a
okay.
forwarding.
People may have good faith on your officers.
No, my lord.
It doesn't make him a
And where's the
thoughtful
form, my
character.
lord? If my lord goes to the language of this letter, page 13, there is a form. There is a specific, my lord. There has to be forwarded by letter, my lord. Only this will not speak, my lord.
That I don't know.
I'll come after tomorrow, my lord. My lord, consider
Then I
then
don't-
only, my lord.
I'm Mr. MS Laskar, counsel for the petitioner. So Mr. D. Goel and
Sending other PH.
standing counsel for PHE. Raised for time till 28/6/2023 to produce instructions as to whether
Or else, my lord,
The-
tomorrow, my lord.
fixed deposit receipt for sum of rupees 4,46,000 within bracket annexure Roman 3 was deposited with the tendering authority. Was deposited by the petitioner before the tendering authority. list of 28. 6/20/23, the motion column.
Status quo means that will not
Yeah,
hamper
wait.
either.
Once he says, don't go ahead, in 2 days' time, don't go ahead.
Reply, Lordship.
That I'll, my lord, that I am guaranteeing, my lord not put it into it. All right.
Don't give a guarantee because otherwise you will be,
No, I can
Uh,
guarantee, my lord, with
I
this
can-
kind of petitions, I can guarantee. My lord.
I
All
can
right.
assure you will be in trouble.
All right.
Deeply obliged.
Yes, 17.
Petitioner is the owner of a plot of land, your lordship, Kopatnadar. And that land was acquired by GAIL, your lordship, under the Petroleum and Mineral Pipelines Acquisition of Right of User in Land Act 1962. What has happened, your lordship?
You have to issue a notice.
Yes, my lord.
Yes, notice.
Mr. K. P. Pathak, counsel for the petitioner, and Mr.
Yes, Mitra.
S. Mitra, counsel for respondent number
1.
1.
On behalf of S. Mitra standing down to bail. On behalf of S. Mitra standing down to bail.
Perhaps
Okay.
two or two.
On behalf of S. Mitra,
One
standing
and
counsel for the said respondent. Okay, then we will be appearing for 1 and 2.
Lordship, 2 is the Quasi Judicial Authority. It's a competent authority, Lordship.
So it is GAIL,
Yes,
ultimately it is of GAIL.
right,
uh,
Lordship. one.
And Mr. M. Sitya, government advocate appearing for respondent number 3. Next. Para. Issue notice motion returnable in 4 weeks. Requisite extra copies of the petition is out on the runner. Department counsel, government advocate and department counsel. In course of the day, next one, petitioner shall take steps within 2 days for service of notice on respondent number 4 and 5 by registered post with AD. As per the government counsel for the petitioner is at liberty to collect postal receipt number and submit postal track report prior to the next date of listing. Next one. The tendency of the repetition shall not be a bar for the respondent authorities. Number 1 and 2. To make an appropriate inquiry regarding non-receipt of compensation by the petitioner and take appropriate measures. Next, the learned standing counsel for the respondent numbers 1 and 2 shall send a downloaded copy of this order to the authorities to bring the order to the notice of the said authorities. List after 4 weeks.
Lordship, the name of standing counsel Gail may kindly be reflected in the cause list.
Okay, registry shall reflect the name of SC GAIL, GAIL, in the cause list while listing the matter next.
Lordship, in the synopsis of, Lordship, I had a small prayer. In the synopsis of the case, there's a small typographical error.
Okay, do it, make correction in his
Yes.
copies also.
Deeply obliged.
Obliged.
$59.
Please, your lordship. I think this case came up before our lordship manner last week, my lord. And the lordship was pleased to call for the, my lord, the minutes of the meeting, my lord.
Now that I'm placing the minutes of the meeting. Minutes, the second page is the minutes. My lord will find the top. Minutes of the meeting with empanel contractors of WSC, my lord. My lord will mark my thing that it is W4
of WSC for supply of loans under block level cluster. My lord, these two things, NH, DP and CHCDS, held on 8 December 2022 at the conference hall of Director of Handloom and Textile, Assam, Ambari, Guwahati. My lord. Now, my lord, then my lord, this at the bottom, my lord, a meeting with the here from the my lord starts a meeting with the MPanel, my lord, MPanel suppliers of WSC, my lord. Tender number this, there is the tender number, was held at the conference hall of Directorate of Handloom and Textile, Assam on 8 December 2022 in connection with the supply of looms and accessories to block level cluster, such and such block of NH, DP and my lord CHCDCS. So my lord, basically my lord, now I will take my lord to lord's page number 26, my lord, of the writ petition. My lord, there was a meeting, no doubt, but meeting for what, my lord? Meeting of the empaneled suppliers of WSC, that is Government of India, my lord, like my lord, CPWD, Central Public Works Department and Public Works Department in the state. These are two different entities. They almost do the similar works. They go for construction, but two different entities, my lord. Here, my lord, we do not have, state government do not have any empaneled list. We don't have that. This is, my lord, WSC. This is central governments. Since they, we are the, my lord, for central government, they give us the fund for this, my lord. I will take, my lord, in the latter part of the my lords. My lord, what happened here? We have, since they don't have manpower, we implement it according to their terms and conditions, but it is their empanelment, not ours. That tender was called by WSC, not by us, not by the state government. My lord, these two things I wanted to clarify. Now, my lord, the next page. After a threadbare discussion, the following decisions, my lord. Supply of such supply of HSS item shall be made as per the approved rate of WSC tender number this. That is page number 23 of the writ petition. It only, this meeting pertains to only that tender, my lord, of WSC, that is which is in page number 26 of the writ petition. Not our, this was not done by us. We did not publish this. We did not call for this tender, my lord. That was by a Government of India entity, not by us. But since they don't have any implementing authority here with us, they do it all together. My lord will find the names of WSC people also here in this. These are the two things. Then coming, my lord, if you go proper down, my lord, number 4 of the thing, my lord, my lords, page number that is, my lord, payment of 90% against the supply order, that is Government of India share, shall be made by the director. Why, my lord? Because Government of India will transfer the money and we will pay. But my lord, tender is not ours. Money is not ours. We just, my lord, since they need hands to implement it, because we know better the surroundings, the state. That is why they do through us. And my lord, number 8, that is important for us. Suppliers shall have to submit an undertaking indicating their willingness for supply of as per the approved rate of the WSC Guwahati. So, my lord, that was in pertaining to the tender of this page number 26. That is that. My lord, in our tender, that is our money. My lord, we have called it. We do not have any empanel list. When this Government of India, again, my lord, they will publish any tender. Obvious, my lord. They are empaneled, they will get it there. But here, my lord, we don't have that. They are trying to take advantage of different. Suppose, my lord, I have a empanelment with CPWD, and state PWD doesn't have that. They cannot take advantage of that empanelment. Since I am empaneled there, I have to be only that particular person will have the right to, my lord. That will become a monopoly, my lord. My lord,
what happens to that act which says that the empanelment is always permissible?
But we don't have. So either, my lord, we have to go for fresh empanelment, or we do not, my lord, call for tender. Since we Let them show a single document where it says that government of Assam Directorate of Handloom and Textile has given them empanelment. Let them show a single document. We don't have that. Either my lord has to, my lord, stop this, that you first go for empanelment, then only go for a tender, my lord. We don't have that, my lord. That is the problem. They cannot take advantage of that.
Yes, Mr. Datta.
May I submit, madam? I have given a compilation, my lord. Can you take up that pattern, that compilation, madam? For a moment, madam. I'll take my lord 2 to 3 minutes. My lord, page 2, my lord. Lordship may kindly see, my lord. Page 2, my lord. Well, here, my the government of India, my lord, the Ministry of Textile, my lord, had introduced, my lord, one program, my lord. It is known as National Handloom Development Program, my lord. Now, my lord, lordship will see below, my lord, 2, my lord. The NDPS has been formulated for its implementation during the financial year 2021 to 25-26. My lord. Lordship is clear, my lord. Now, my lord, next page, my lord, 3, my lord, serial number 3, my lord. At page 3, my lord, the component.
I merely heard you, whether I'm clear or not, that I don't know.
I was saying, my lord, for the period, my lord.
Yes.
2021, 22 to
Yes, yes.
25-26.
Yes,
my lord.
yes.
Now, page 3, my lord, serial number 3 at top, my lord. What are the components, my lord? My lord, there are 7 components, my lord. We come under this, my lord, small cluster development program, small CDP, my lord. Lordship will mark that, my lord, small CDP, my lord. CDP, my lord. Now, my lord, lordship will turn to next page, my lord, page 4, my lord.
Yes.
Page 4, my lord, serial number 5, my lord. Who is the implementing agency, my lord? IA, my lord. Well, here IA will be, my lord, IA for the second part, my lord. IA for handloom marketing assistance. Roman 1, my lord, director in charge of handloom and textile, sericulture in the states of Union Territories. So in the instant case, my lord, Directorate of State Handloom, my lord. Now, lordship will ask me the question, my lord, what is cluster development program, my lord? The amount, my lord. Next page, my lord, page 5, my lord, at top, my lord, small cluster development program, my lord, quantum of financial assistance, my lord. This program is to provide need-based basic assistance up to 2 crores, my lord. So in the instant case, my lord, in the tender, my lord, there are 10 CDPs, and which amounts to, my lord, near about 4 crores, my lord. So it will automatically come under this, my lord, small cluster development program, my lord. Lordship, I found that, my lord.
Yes.
Now, my lord, A4, my lord, A4. In the tender also, my lord, they have stated, my lord, state level project committee, my lord. The SLPC will be chaired by the state director in charge of handloom with the members from the handloom organization, Apex Weavers Cooperative Society of State Handloom Corporation, leading exporter, head of office of WFC, my lord. Concerned, representative of NHDC, representative of IA, that is implementing agency, and a weaver from a group of SH so and so, my lord, will be responsible for scrutinizing the project proposal, validating the action plan, monitoring, evaluation, etc., and will also recommend the IA. Silk-based handloom cluster may be implemented by the state director of sericulture. If there is separate directorate of sericulture in the state, state director shall submit the copy of the proposal of the respective WSC at least 2 weeks before the SLPC meeting for the response. So in this committee, my lord, they approve a scheme, my lord, and that scheme is to be forwarded to the Union of India, my lord, and they will get a sanction, and the amount will be sent, my lord. Now, my lord, lordship will see, my lord, A5, my lord, second paragraph, my lord. In case state directorate do not forward the cluster proposal in 2 months' time after its submission by the IA implementing agency, WSC concerned shall directly submit the proposal to the office of the DCHL under intimation to the state director. I mean, this is not relevant, but I am also just pointing it out, my lord. Now your lordship will see, my lord, the next page, my lord, page 6, my lord. Next page, my lord, page 6, my lord, at serial number 7, my lord.
But then, Mr. Dhar,
My lord.
your argument will not be acceptable. You see in your, this page 44 is the tender notice.
My lord,
Right.
my lord, my lord,
This is your tender notice.
My
See in the last part,
my lord.
it says for implementation of cluster development program as per Government of India sanction letters, number so and so. So this is not your project.
This is our project, my lord.
How can it be, my lord?
Can't be.
My lord will see page number 26. When WSC comes up, my lord, they have a different tender. Under their head, under their name, my lord, that is there. And when we do it, my lord, it's a different fund. My lord will compare these two tenders. Page number 26, my lord.
My lord, I have annexed at page 28, those sanctions, my lord.
20.
28, my lord. 28, which is regard to 3, no? 3 CDP, my lord. Page 28, my lord. This is the sanction, my lord. This order has been mentioned in the NIT, my lord. 1st September 2022 and 1st December 2022.
No, we'll have to issue a notice, Mr. Gaurav.
Before that, my lord, only one aspect, my lord, on that guidelines, my lord. Page 8, my lord. Page 8, my lord. Page 8, my lord. E, my lord. Page 8, my lord. On the left side, my lord. E. Small e, my lord. For lordship, you got it, my lord. Page 8, my lord.
Yes.
E, my lord. For empanelment of suppliers of each item, action shall be simultaneously initiated by the state director to invite bids through open tender. For tendering, state director concerned shall follow state guidelines and will constitute tendering committee having representatives of WSC concerned as member. Whether they have done this, my lord. Before issuing the tender, my lord, whether they have done this, whether they have followed this one, my lord.
My lord will come to page number 46 of the tender notice.
No, if it is not there, it is not there.
I have not finished.
If it is not there, it is not there.
I have not finished.
My lord will peruse page number 46 of the tender.
Let's make the third complete.
My lord.
Yes.
Lordship will see, my lord. There should be an empanelment. Another empanelment, how can then empanelment be there, my lord? Then lordship will turn to page 73, my lord, of that guidelines, my lord. 73, my lord. These are the list of items admissible under the scheme along with the cost norms, my lord. Page 73, my lord. Annexure A8. These are the materials, my lord. For empaneling the, my lord, the suppliers, they were shown this list, my lord. They agree to this list, my lord. Therefore, they are empaneled. Now your lordship may turn to the act, my lord, for a once. The act, my lord, this Assam Public Procurement Act 2017, my lord. I have flag marked, I have flag marked it, my lord. The act, my lord. Act, my lord, clause 19, my lord. That is internal page, my lord, 1040, my lord, at the top, my lord. My lord. Clause 19, my lord. Registration of bidders, my lord. With a view to establishing reliable source for a subject matter of the procurement or a class of procurement, which may be commonly required across procuring entities or repeatedly required by a procuring entity may maintain a panel of registered bidders, my lord. My lord, this one is 19.1, my lord. Now, lordship will turn to below, my lord, 19.5, my lord. 5, my lord. Where a procuring entity does not register bidder in respect of the subject matter of procurement, it may use the list of registered bidders of any other procuring entity, if any, my lord. Now the question is, my lord, before
No, may can't be read as shall.
Yes, my
In respect of this act, may cannot be read as shall.
my lord, but in the if that is true, my lord. But when you go to the rules, my lord, rules says, my lord, it's the shall, my lord. So even also, my lord, but before floating this tender, my lord, whether they have empaneled, my lord, suppliers, my lord.
Where
Which
where is the rule you said?
That is in the, my lord, guidelines at page 8, my lord. Page 8 of my guideline, my lord. Clause E, my lord. Page 8, my lord.
Eight.
Page 8, my lord, clause E, my lord. They have not followed it. my lord. Share that. Page.
Yes.
But in the rules, my lord, it says shall, my lord.
Where is that?
My lord, rule your lordship will find, my lord. I have also annexed it, my lord, page 1583, my lord, 1583, my lord. 1583, my lord, internal page, my lord. That is also 19, my lord, 19.5, my lord. The procurement of a subject matter shall be done by the procuring entities. My submission will be, my lord, they cannot float this tender, my lord, because they have not followed the guidelines as enumerated in clause E of the guidelines, my lord. That is at page 8, my lord. And here, my lord, the 90% share will be from the government of India, my lord, 10% from the beneficiaries. And this 10%.
No, but still, what Mr. Dhar is saying has some logic behind it.
My lord.
You see, page 26, the government of India also floats a tender.
Yes,
State government also floats a tender.
my lord. No, my lord.
So therefore, therefore there are two different methodologies adopted.
Exactly, my lord. No, my lord. No, lord. That is a wrong.
They are
my
just
lord.
trying to
That
club it back
only the
together, my lord.
concept, my lord. Tender for supplying of goods is one thing, and tender for empanelment of bidders, my lord, that is a different thing. So far, page 26 is concerned, my lord, it is a tender for empanelment of the suppliers, my lord. And so far, the present NIT is concerned, my lord, this is for supply of the materials, my lord. My friend is referring, my lord, the tender numbers mentioned. It is a tender floated for empanelment of the suppliers, my lord.
It's only a notice, not a tender.
Yes, my lord.
26 is only an empanelment
Yes, empanelment. For the,
for that particular tender.
yes, my lord. And he is confused regarding that, my lord.
No, he's right. No confusion.
No, my lord, the officer published the e-tender white number so and so. But that is a tender for, my
It's
lord,
okay. Your claim is that the central government doesn't issue a tender. It is only issued by a state government
yes. but
because
e-
of respondent. That is what your
Yes, but
argument
even,
is.
even in the instant case also, my lord, before floating this tender, my lord, they have to empanel the suppliers, my lord. That clause E has to be followed, my lord. Because it is the money from the government of India, my lord. It is not their money, my lord. They are only sitting here as an implementing agency, my lord. Nothing more than that.
Okay, let me consider it.
Right.
Deep level. These are for poor waivers of the state mallet. We are trying.
It's okay. Once there is a guideline, there is a guideline. You can't help it. The state law says that you may consider. Rules said you shall consider.
My lord will come to
I am
just page
stressing
number
on my
46
lord.
once, only once, my lord.
I am stressing morely on my lord's clause E, my lord.
46.
My lord, now, if my lord interprets means, my lord, the whole thing has to go, we have to go for fresh empanelment of the state. The
Exactly.
state, my lord, this will, my lord, delay, my lord, things. My lord, their contention is that they just want to create a monopolistic thing, my lord, syndicate.
No, that is a permissible. Law-
That is what, my lord, we don't want.
Law of the state permits it. You can't help it.
Page number 46, my lord. There, my lord, in this number 2, registration of contractor and bidders.
No,
Any
you see-
contractor bidder willing to take part in the process of tendering,
But Mr. Dhar,
my lord.
he can't move the legislature, but you have the capacity to move the legislature. Legislation in its wisdom has created this concept of having an empanel in the suppliers. And it is not wrong. Because even in our court, we have empaneled suppliers. If I need a pencil, I don't call out tender. There are empaneled suppliers. I just tell my courtmaster to get me a pencil tomorrow and he gets it from his supplier. So I don't issue tenders for each and every pencil or pen I use.
But my lord, this is for the whole of state.
It's okay.
It's a huge quantity of.
No, even in court, we have huge consumption of pencil and pen. Don't worry about that.
No, I understand that, my lord.
It may be value may be less, but consumption is huge.
My lord will consider, my lord.
I'm obliged.
But
I may be excused, my lord.
No, I'll consider class orders in the chambers.
my
I'm
lord,
obliged.
my lord.
This you will collect it from the courtmaster tomorrow.
And for respondent number 1 and 2.
Okay, just a minute. This item number.
59.
Okay.
68.
May I please?
I have already shared the copy. May I please, your lordship? I shall be very sorry, I could not get any instructions. So-
An issue in state, because
Yes,
we
sir.
don't.
Yes.
Heard Mr. Hassan Tamale, counsel for the petitioner, and Mr. M. Sharma, Leonard, counsel for the respondents. Petitioners, petitioners, and for the respondents. Next one. By filing this petition under Article 226 of the Constitution of India, the petitioner has assailed the notice of demand dated
23/5/2023.
advocates notice of demand dated 23/5/2023, by which sum of rupees 2,81,34,392.26 as on 27/8/2021 was demanded. Oh, no.
Your lordship,
Wrong.
38-4.
It is 2, 18, 74, 739.36 as on 30/4/2023 was demanded. So the challenge is made on the ground that the petitioner had entered into a settlement with the respondent bank and accordingly the authorities of the Canara Bank by letter dated 29/7/2022 within bracket annexure 6 bracket closed had rescheduled the dues of the petitioner to the extent of rupees 277.83 lakh with interest. So it is projected that the petitioner has not defaulted in making payment of the settlement amount. Next. Issue notice of motion return within 4 weeks. Requisite extra copies of the petition be served on the counsel for the respondents in course of the day. Next, heard both sides on the appeal for interim relief. On a consideration that in the advocate's notice 23/5/2023, there is no reference to the settlement letter of the bank dated 29/7/2022, despite objection made by the counsel for the respondents, the court is inclined to provide that provide as an interim measure until the next returnable date that during that till the next date of listing, no coercive steps be taken against the petitioner or recovery of dues in contravention of bank's letter of settlement dated 29/7/2022 within bracket annexure 6. List after 4 weeks. The petitioner shall produce a certified copy of this order before the concerned bank branch to bring the order to the notice of the said authorities. And give a copy to him also.
Yes, I have received your lordship.
No, a copy of this order.
Yes, Lord.
Give it to him.
Yes.
What do you want to say?
Your lordship, that the total outstanding amount as on 30th/4/2023, it is 2,81,34,392.
281.
Yes, sir.
Where is that?
It's para number 17, page number 12, your lordship.
No, I'm writing from this advocate's notice.
Yes, your lordship.
It is total as on 20.
2/18/74/379. I'm writing from here, page 46.
Yes, your lordship.
Lordship, in para 17, I have mentioned the amount as 281.34. That is wrong, so I may be allowed to correct it. Because amount should be
before that, before last time, say, on the prayer made by learned counsel for the petitioner is permitted to make correction in the in paragraph 17 of the writ petition to incorporate the correct outstanding dues. So such corrections shall also be made in the copy provided to the learned counsel for the petitioner, respondents. Okay.
And your lordship.
I'll take a break and come back.
Two thousand twenty-two, my lord. Lease was granted for a period of 1 year, my lord. And though by order dated 13/7, he could operate the photo stand from 30/30, my lord.
No, for that you can seek remission. We can't stay the NIT.
But earlier also, my lord, your lordship perhaps seen, my lord, earlier in 2019, my lord, he was issued the same parking place, my lord. So lordship will find page, page 15, my lord. Page 15 with effect from 1/1/2020 to 31/12/2020, my lord. But from March to.
No, you submit your representative, it will be considered, but no stay of the tenders. Tender process will not be stayed.
He can also participate in the tender process, it is open for him also, lordship.
For extension, you don't have a fundamental right. I don't find one.
Otherwise, my lord, the present lease period, my lord, starts issued on page, my lord, 13, my lord, page 22, my lord.
Yes.
Issued on 13/7/2022 for a period of 1 year, my lord. How? Even, my lord, if it is counted from 13/7, my lord, it will expire on 13/7/2023, my lord. But
No,
by,
that is okay. They will consider it.
but by issuing notice, my lord, issuing the fresh NIT, my lord, page 20.
No, how will this stay help you?
My lord,
How will this stay help you? You only continue with your earlier lease. That we are not encouraging. You can at best ask for remission. That's all.
Otherwise, my lord, he is entitled 1 month, my lord, that is. His term of 1 year will expire on 13/7/2023, my lord. It is clear, my lord. How it can be, my lord?
Pardon me?
My lord, page 22, my lord.
Yes,
Page 22, order was issued on 13/7/2020.
it's okay.
My lord, may I kindly peruse page 22 paragraph, first paragraph, lordship. With the retrospective effect from lordship 1/7/2022 to lordship 36/2023 for 1 year period, lordship.
My lord, how it can be with retrospective effect, my
They
lord?
have lordship accepted this, they are running this, or today lordship they have said that, how
No,
can
my
it be
For
retrospective?
this, my
effect,
lord,
lordship?
it is not has submitted a report.
My lord, may I kindly peruse page 22,
Whatever
lordship.
reason you ask for remission,
Yes.
I'm not interfering with any of the reasons. Tender process, I'm not staying.
My lord, my prayer is that tender process maybe stayed for 1 month, my lord. In the meantime, it will continue 1 month, my lord.
Not even for a day. Not even for a day. Fundamental right you show it's validated. It's not a violation, it's a contractual right which is validated. But Mr. H. M.R. Khan, the counsel for the petitioner,
It's about to.
and Mr. K. Gogoi Langan, additional senior government advocate appearing for
Lordship, I am for 1 and 2, lordship.
respondent was 1 and 2. Next. By filing this retention in the Article 226 of the Constitution of India, the petitioner has assailed the issuance of NIT dated 26/2022 in respect of Shiraj Patti, SHIRAJPATTY, Bazaar Petrol Auto Parking. Full stop. The case of the petitioner is that he is the present lessee of the said parking, which was settled by order dated 26/12/2019 for a period from 1/1/2020 due to 31/12/2020. Full stop. As the COVID-19 pandemic had set in, the petitioner could not operate the parking. Full stop. The authorities of the municipal board, Hailakandi, issued a fresh NIT on 17/6/2022 for a period from 1/7/2022 TO2 36/2023. And they said and in the tendering process, the petitioner was settled with the said parking. Full stop. The learned counsel for the petitioner had submitted that as the settlement period was for a year, retrospective effect of settlement could not have been given effect from 1/7/2022, as the settlement order was made on 13/7/2022. So accordingly, it is submitted that the fresh tendering process be stayed for at least a month, so that the term as envisaged by NIT dated 13/7/2022 would expire. First off, it is submitted that if the tendering process is not stayed, the petitioner would suffer a loss for the previous term. Next paragraph. The prayer made in this petition is opposed by the learned additional senior government advocate. Next paragraph. Having regard to the nature of grievance raised by the red petitioner, the court is of the considered opinion that at best, if the petitioner could not operate the parking for the fixed term, notwithstanding that he has accepted the letter dated 13/7/2022 and acted upon it, the only remedy available to the petitioner would be seek remission of the parking parking lease for the period from 1/7/2022 to 13/7/2022. However, for the said municipal MINISCULE municipal period of time, the court does not find this to be a fit case to stay the tendering process, which has been initiated by notice dated 26/2023. Within bracket LHS 6. Next para, the court is of the further considered opinion that as the grievance of the petitioner can be redressed by relegating him, redress if the petitioner approaches the competent authorities for remission, as the loss suffered can be quantified in terms of money, no case for stay of the NIT has been made out. Moreover, the rights available to the petitioner is merely a contractual right, and therefore court does not find any fundamental right of the petitioner being violated. Hence, the court is disinclined to entertain this writ petition, and accordingly, this writ petition stands dismissed. Next, nonetheless, the dismissal of the writ petition shall not be a bar for the petitioner to approach the competent authority seeking remission of the parking lease amount for which he has not been able to operate the parking. Post.
Earlier order may be referred, my lord. Earlier order of this court, my lord. Petitioner approved earlier this court, my lord. Seeking remission from that period, my lord. For that period, my lord. This was not considered, my lord. My lord, page
Page
16, my lord. 17.
No. Just over there. The learned counsel for the petitioner had also referred to the order dated 17/12/2021 passed by this court in WBC 6833 of 2021, wherein this court had provided that in the event the petitioner files a representation before the concerned authority of the Hailakandi Municipal Board regarding the prayer made by him regarding returning of the proportionate amount of money deposited by him, the same shall be considered by the said authority as per his entitlement and in accordance with law, by following the relevant provisions of law and the rules in force and as applicable.
Terms of that order, my lord, petitioner submitted representation next week. my lord.
First of all, it is projected that in terms of this order, the petitioner submitted a representation dated 21/5/2022. But the same was not considered. It said regarding the course of the constitutional opinion that they cannot be a successive rate for the same relief, as the petitioner has already been provided with an order dated 17/12/2021 in WBC 6833 of 2021. Post on. However, at the appropriate time the petitioner has not approached this court for willful and deliberate. By complaining of the willful and deliberate non-compliance of the order of the court. Post accordingly, it is without. No, accordingly, it is provided that the dismissal of the petition shall not be a bar for the executive officer, municipal board, Hailakandi, to dispose of the representation of the petitioner in terms of the hearing before effort order. First of how this time the let's just say horse interest as a disposed of without considering this as a direction of the court. I'm not taking issue of direction, but it is only we hope that they would consider, because there can't be a successive rate for the same relief which you have already got.
Settled.
The only remedy is contempt. Successive rates can't be issued.
62,
Non-payment of bill. It's, B. Prasad, counsel for the petitioner, and Mr. K. Govind Anand, additional senior government advocate appearing for all the respondents.
I'm for 1, 2, and 3, Lordship.
1, 2, and
Finance is
3.
there. So,
Finance, finance will be
Mr. B, I will inform. He's present.
Mr. B. Govey, standing counsel for finance. He will be for 4.
Lordship, 4.
Non-payment of bill. Notice extra copies in course of the day. Pendency shall not be a bar.
Lordship.
63,
You certified copy before whom? Certified copy will produce before whom?
Before the managing director, Assam States Corporation.
Before MD, Assam States Corporation. Respond number? 2. Okay. Yes, Mr. Rashid, 63.
This is regarding the settlement of market Miller. And earlier when it was issued, I filed it energy Miller tender. So it was, I was
Who's appearing for BTC?
Now Miller the BTC. Again tender issued Miller.
My lord,
You are appearing for BTC.
no, my lord, PNID. For PNID, my lord.
No, BTC will be required here.
Yes, my lord.
SCBTC. SCBTC. We'll wait for some time.
And now we have 2 PM. I may.
Okay.
If you at 2 PM. Miller.
64,
May I please Lordship, this is a matter relating to the settlement of the Gadubanga weekly market Lordship. The in compliance of the honorable court's order dated 17/11/22, the Tikajuli Anchalik Parish Panchayat invited the pay standard, that is page 35 Lordship. And Lordship, without publishing the result of the first tender.
No, there can't be a continuous process. There can't be a continuous process like that. It has to be retendered. You see, number 1 did not take it, number 2 did not take it, now you are number 3.
Yes,
So that can't go on for like that.
because after.
No,
at the
after
first
settlement, no, after settlement, you see, there's no, is there a concept in tender called what you call waiting list? I'm not
But,
aware of it.
Lordship, they have not till today, they have not hang up the result of the non.
No, you see,
but,
it is your own
without-
case. It is your own case that number, there was a first highest
But
bidder.
only I.
He was declared a defaulter. Then it went to the second highest bidder. then it came, they also did not take it, and now you're the third highest bidder,
Yes.
correct?
Yes.
So is there a concept I
But
don't
it-
know?
It is an unofficial lordship, just, but they did not publish any notice, it's unofficial. Just after visiting the office, I came to know that.
That was a bid of, that bid was cancelled in November 2022.
No, lordship, it was not cancelled. Without cancelling that bid dated 19/11/22, they have issued the fresh standard. That is dated 15/5/2023, page number 71.
No,
No, without cancelling the earlier one, they invited
no,
second one.
just tell me. If there's, nobody is there as a successful, what you call, no agreement is there with someone. What is the necessity of cancelling it? There was a successful bidder. He was given the offer. He did not take it. It was given to the second one. He did not take it. What is wrong in the retendering?
Because after first and second, I'm the highest bidder. So I may be considered.
No.
And then now
They will-
recently
they will-
recently what they're doing here, Lordship, they're doing the weekly basis, they're calling up the tender on weekly.
That is why
basis.
it has to stop. It has to be sent to auction. If you,
And then, and day before yesterday, we came to know that the day-to-day basis, they are now calling day-to-day basis, like,
that will be stopped. But we are not interfering with the tender process. But Ms. J. Paul, then counsel for the petitioner. And Mr.
Lordship, I am
Gogoi,
for one and
London.
four, Lordship.
Additional Senior Government Advocate appearing for respondent number
1 and 4, Lordship.
1 and 4.
Lordship,
PNID.
I'm appearing on behalf of pending of the PNID.
Okay,
For
Mr.
Respondent number 2.
Your name?
My lord, U Sharma,
Mr. U. Sharma, the counsel appearing on behalf of
S.
Mr.
Datta,
S. Datta, standing counsel for PNRD department, appearing for respondent numbers
2, 3, 5, 7, and 8.
2, 3, 5, 7, and 8. Next para. By filing this bid, writ petition under Article 226 of the Constitution of India, comma, the petitioner has assailed the NIT dated 15/5/2023 for settlement of Gorubandha, GORUBANDHA weekly market for the period from 1/7/2023 to 36/2024. Next paragraph. The case projected by the petitioner that in the previous tendering process, which was called by NIT dated 19/11/2022, comma, the petitioner was the third highest bidder in the said tendering process. Full stop. It is alleged that the notice of settlement of the said NIT dated 19/11/2022 was never published or hanged in the notice board of the Dhekajuli Anchalik Panchayat. Full stop. It is projected that the as the said market was not settled to any to the highest bidders, comma, the petitioner had submitted a representation. Where is the representation?
Lordship, annexure 11, page number 89.
80, representation 7/6/2023. For being settled with the said weekly market. First off, in the said representation, it has been projected that the first and second highest bidder had relinquished their right over the tendered market. First off. Next, but accordingly, the Land Council for the petitioner has submitted that as the previous tender process was not cancelled and was set aside, the petitioner who was the third highest bidder had a right to be offered the market for the for the concerned period. First off, accordingly, it is submitted that the fresh tendering process is not sustainable. And she is paid for setting aside the said tendering process. Next, but having heard the learned counsel for the petitioner as well as learned additional senior government advocate, as well as the learned departmental counsel in the matter, the court finds that even if the statement made by the learned counsel for the petitioner is accepted, the previous NIT was for a period from, where is the period given in the first NIT? It will expire on
30th June.
38. When it will expire?
36 2024.
36, 2023.
Yes.
24, actually. The fresh one. 36.
No, earlier.
Earlier
There is
than-
lordship 36, 23.
36, 2023. First of all, the said period is expiring shortly. First of all, therefore, even if the prayer made in the representation of the petitioner is allowed today, the petitioner would have the benefit of operating the market for only 3 working days, which would not benefit the petitioner in any manner. First of all, therefore, as the normal tenure of the Gorbanda weekly market would otherwise expire on 36, 2023. The court finds no reasons to entertain this writ petition and to stay the tendering process for the said market for the period from 1/7/2023 to 36/2024, which is not found to be in public interest. Full stop. Moreover, as the petitioner is the third highest bidder, the petitioner has no fundamental right, and no fundamental right of the petitioner has been infringed for not settling the said market with the petitioner for the remaining tenure. And according to this, court is disinclined to entertain this writ petition. According to this, writ petition dismissed at the motion stage without issuance of notice on the respondents.
Was
19, stay back at it.
Even this case, the applicant, respondent, applicant filed the stay vacating lordship, but last occasion, the second respondent took time for filing the affidavit lordship. In this case, I think record will be required.
Lordship, in this matter, I have received the instruction by my lord from BDO. I like to file affidavit, my lord.
Just a moment.
After filing my affidavit, my lord, lordship can dispose of entire matter, my lord.
Just tell me what happens if I vacate the order? What is the implication if I vacate the order?
Then president will go out. my lord.
Yes. Yes, sir. Same function with person.
He's holding the post right now.
I am holding the post lordship, the private respondent as applicant this, they have filed this IA lordship for vacating the interim order. If it is vacated, then I'll be ousted from the office lordship.
You'll ousted from office.
Yes, sir. So
But that
interim-
can't be done,
My lord,
Mr. Khanikar.
government will file affidavit, my lord, and after that, my lord, your lordship will dispose them.
interim
No, no,
matter-
that's okay. I'm asking you because this matter is pending since 2022.
Okay.
I don't find that this, we can entertain this application and non-suit the petitioner.
Only because of that, my lord, I think that, my lord, he will file the affidavit, my lord, after that, my lord, the entire man.
No, that is okay. But what is the point in keeping this pending? That's what my question
I-
is.
I am, madam, regarding I am.
This IA.
I don't know, I have, your lord,
Otherwise, lordship, I have nothing lordship. They have not make any ground lordship. The interim order was first paid with the record lordship. After pay, lordship kindly paid the order lordship, which was challenged in the IA lordship for vacating. The nature of the order lordship in IA lordship will fight.
Because as per the resolution, he was the chairman,
yes, yes. President.
president, president. And therefore, this court, the main writ petition is that he would be permitted.
Well, according to section 15, mother, no constitution has been initiated, mother, within six months, mother, if one rejected, mother. But here, my lord, within 6 weeks, mother, 3 meetings were held, mother. In the last meeting, mother, the resolution was passed. Only on that ground, mother, the interim order was passed.
Approval was given, lord, they failed to.
No, you see, unnecessarily these matters are pending. If you go back and now more than 6 months have gone, you can always move a resolution. There's nothing is surviving now.
No, no.
Repression has become infructuous.
Not satisfaction, lordship, they come up with the affidavit, interim matter.
You know, why we need an affidavit? Just tell me what will do? Infructuous matter, what will the affidavit do? You have come against no confidence motion. After 6 months, it can be legally done.
Yes, sir.
Whether you
Again,
have
mother,
an,
no
whether you
protest
have
was
an order of
initiated.
this court or you don't have the order of this court, law will operate.
Yes, sir.
So why you keep it pending? I don't find a reason. But Mr. S. U. Ahmed, on the council for the
Petitioner.
uh, just say in the IA. I just say Khanikar counsel for the petitioner. And Mr. S. U. Ahmed, on the counsel for the opposite party number 1. Next one. In view of the order which is proposed to be passed in the connected writ petition, this interlocutory application stands closed. Then writ petition. Next one by Mr. S. U. Ahmed, the counsel for the petitioner. Mr. S. Dattar, understanding counsel for the PNRD.
1 to 5.
Respondent numbers 1 to 5. And Mr. A. Khanikar, standing counsel for the, counsel for the Private respondent
Private
numbers. 6-2.
6-2.
No, you are the president.
Yes, Lordship.
You are the president.
6 is the Anshalik Panchayat
Yes,
President.
7 to
The
15.
petitioner is the
Anshalik-
Gaon Panchayat President.
Yes.
Oh, acha, so you will be appealing for
No, no,
6.
President is the elected body, madam. Elected. person.
President elected body.
Yes.
Okay, so 6-2.
No, 7-2. 7-15.
Okay, 7-15. There is no representation of the respondent of the 6. Next paragraph. By filing this repetition of Article 226 of the Constitution of India, the petitioner, who is the elected president of 41 number Makhibaha, Makhibaha, Gaon Panchayat. Full stop. By a resolution dated 4/8/2022, no confidence motion was brought against the petitioner. Full stop. It is projected that the intimation of the notice of no confidence motion was received by letter dated 16/8/2022, and the petitioner gave its approval to hold the meeting on 18/8/2022. Full stop. It is projected that in the meeting held on 18/8/2022, the no confidence motion had failed. As there was no consensus of the members attending the said meeting, so accordingly, the secretary of the Gaon Panchayat, by a letter dated 25/8/2022, forwarded the matter to the BDO cum executive officer, TU Anchalik Panchayat. Poster. It is projected that in violation of the provision of section 15 within bracket 1 of the Assam Panchayat Act, 1994, meeting was directed to be convened on by a letter dated 2/9/2022, right?
Yes, sir.
Petitioner was directed to hold meeting on 5/9/2022. The case of the petitioner is that on the date fixed, i.e. 5/9/2022, the meeting conducted by the meeting to consider no confidence motion conducted by the Anchalik Panchayat was cancelled due to absence of 2 members, including the petitioner, and that in violation of the provisions of section 15 within bracket 1 of the Assam Panchayat Act, 1994, the adjourned meeting of no confidence motion was held on 19/9/2022, and a resolution dated 19/9/2022 was passed against the petitioner, which is impugned with the present writ petition. Full stop. This court, by order dated
39.
30/9/2022, as an interim measure, permitted the petitioner to continue in office of president of 41 number Makhibaha, Gaon Panchayat until further orders. Full stop. Having regard to the submissions made by the learned counsel for the petitioner, standing counsel for the PNRD department, and the Learned Counsel for the private respondents, comma. The court is of the considered opinion that on failure of the no confidence motion, comma, such resolution cannot be moved for a period of 6 months. And thereafter, the court does not find that there is a bar in the provisions of Assam Panchayat Act and rules framed thereafter to the members of the board of the Gaon Panchayat to bring a fresh motion for no confidence against the petitioner. Full stop. Therefore, comma. As there's a statutory right to the members of the Gaon Panchayat to bring about a fresh. I don't like that. You say that in view of the statutory remedy available to the members of the Gaon Panchayat, take recourse to appropriate provisions if they find themselves dissatisfied with the functioning of the petitioner, comma, the court is of the considered opinion that no point could be served in keeping the matter pending. Full stop. As this court had kept in abeyance the resolution adopted in meeting dated 19/9/2022. The court is of the considered opinion that the said interim order will be made absolute. Full stop. However, this order shall not preclude the right of the members of the board of directors of Makhi Gaon Panchayat take appropriate measures if they find themselves.
Members.
Some members, okay, members, okay, members also, if they find themselves agreed with the functioning of the petitioner in a manner which is permitted by law. So according to this petition sense, partly allowed to the extent as indicated above. There should be no orders to cost.
Diplomas.
20.
My lord, here, respondent 2 and 4 have filed the interlocutory application for vacation of stay, my lord. My lord may grant me some time, my lord, that I can file my objection.
To issue a notice. Give a date, when should you fix
My
it?
lord, may I kindly have it after the reopening, my lord.
No, that's why I'm just asking, give suggested date both of
My
them.
lord can give it on, my lord, 19th. Or it will be too early, my lord.
19th will be too early, because
Second week, my lord.
in the first week, there will be immense pressure.
25th or my lord.
25th, 27th. 27th, okay. Interlocutory application, heard Mr. K. Chaudhary, Learned Senior Counsel, assisted by Mr.
I mean, yeah, 2 IAs have been filed.
It's okay, Mr. Chaudhary.
Mr. I'm assisted by Mr. H. Hazarika, my lord.
KH Hazarika, counsel for the applicant.
H. Hazarika.
KH.
H. Hazarika.
H.
Harish.
Acha, Harish H. Hazarika, counsel for the applicant. Applicants. As well as Mr. N.J. Khatania, Learned Counsel appearing for the opposite party. Number 4. You're for 4.
No, my lord. I'm for the
Opposite party 4.
Four, my lord.
In the IA.
4. And for GMD, you will be appearing.
GMD,
I'm appearing, I'm representing GMD in this case.
Oh, acha, okay. Uh,
1714 is by GMD and
just a moment. No, this, what you call? Government advocate, Mr. K. Gogoi, government advocate, additional senior government advocate appearing for respondent number 1. And 2 and 3 who are appearing, this Games Village Resident Welfare Society.
I'm my lord.
Mr.
Fourth.
Khatunia.
Yes, my lord.
So Mr. Khatunia will be for opposite part number 2. And this 3, Atul Chandra Kalita
Yes, I'm appearing, my lord.
for him also, at 2 and 3. And this Simplex Infrastructure,
I will be.
you will be appearing.
I'll-
Mr. Ajay Das, council for opposite part number 4. Next paragraph. You should notice in this interlocutory application returnable on 27/7/2023. First off, affidavit in opposition, if any, be filed 2 days prior to the set date of listing. Next paragraph, list on 27/7/2023. Now, this second application is by
By.
1779 Simplex.
Simplex.
You have all
I am for.
Simplex, okay. You have just changed the nomenclature. Mr. Ajay Das for the applicant. Mr. K. Gogoi, additional senior government advocate appearing for respondent number 1. Mr. K. N. Chaudhary, another senior counsel, assisted by Mr. H. Hazarika, counsel for respondent number 2 and 3. And Mr. N. J. Khatunia and counsel appearing for respondent opposite partner number 4 and 5. Same one.
In the petition, my lord, the interim order is
Okay.
still returnable date, my lord.
Okay, in the interim order, this late petition, Mr. N. J. Khatunia for the petitioner. Additional senior government advocate for respondent number 1, 2 and 3 by Mr. K. N. Chaudhary, assisted by and number 4 is by Mr. Ajay Das. Okay. List this matter on 27/7/2023. In view of orders passed in the connected interlocutory applications. 1/4. Post on. It is observed that affidavit in opposition has not been filed by the respondents. As one last opportunity is granted to the respondents to file their affidavit in opposition at least 2 days prior to the next date of listing. Next, list on 27. Just say that interim order passed today stands. Interim order passed by order dated 31/8/2022 stands extended to the next date of listing based on 27/7/2023.
Obliged.
But just for curiosity, what right you have got to object?
But here, 2 plots of land, my lord. In one plot, they have already constructed a,
No, but you are blocking it.
Exactly,
we
that
are
is
not
the
Blocking
issue.
it.
we are not, because my lord, the wall we have constructed in our land, my lord. Not in the other plot of land, my lord.
No, you see, this land is not owned by you.
Yes.
So what is our plot of land?
My lord, because the society, the Games Village Society is managed by us, my lord. And the subsequent development carried out by
That's
the,
okay, since I can't pass any orders right away, but I was not satisfied. Privacy, this one be a privacy.
yes, my lord.
Since I have no other work, I was reading it.
21.
Obliged, lordship.
My lord, in item number 21, we have filed this IA, my lord. I was seeking into that.
This is implement.
Yes,
Any objection?
I am for the read petition, my lord, only. And this read petition is suffering from some problem because of these ailments, my lord. I could
Okay.
not file any objection. Because he said that he has no locus standi. Because one civil suit is pending between both the parties for ejectment of this, my lord, read petitioner.
So
My lord, on last occasion, my lord,
No,
they
just-
took
just-
time
just-
to file an objection.
Just a minute, maybe he's sick,
Yes.
he can't get a, he's 73 years.
Ah.
So therefore, I don't blame him, just trying to understand, what your stand is. Yes,
this event should.
Our stand, my lord.
no, no,
Oh,
Mr. Goswami, because I'm just trying to understand, because he's 73 years, what is the real issue? I just wanted to understand.
No, well, one plot of land, it's
Yeah.
not it's not owned by this applicant, my lord. A government land, my lord.
Yes,
But one civil suit is also pending between the parties, my lord. For eviction of this writ petitioner, my lord. Now, if your lordship wants, my lord, let him be.
no, I'm
included
just
as a
trying to
part-
understand, because this, I have not been able to follow. That's why I'm just trying to understand. Because your prayer is to pass a speaking order.
hmm.
This, respond numbers 1 and 2. 1 and 2 are this
GMT.
this
GMC.
GMC.
Yes.
No, where is that notice?
I don't know.
We are talking about 18 side. A order to the head. A order. Big clear.
My lord, exactly the same issue stands adjudicated, my lord. They have suppressed all these facts and filed the second writ petition. In the IA, my lord, they have annexed that order, my lord.
No, because I'm trying to follow it, not for any other reason, but because the description of right title I did not find.
Yes.
Private
There's
I could
nothing.
not find.
And my lord, the prayer he is making, if at all he has any cause of action, it is for the civil court. 226 court cannot decide, my lord, which dags belongs to whom.
No, exactly, that is the reason since I could not follow it in the
Yes,
first, first blush of reading.
If at all he feels, my lord, he has a cause of action, maybe he can go to civil court. Same issue was adjudicated by this honorable court, my lord.
Is
Please
it-
come to my, yes, please come to page 13 of our IA. That's the order, my lord.
Because if in first blush I can't read and understand. I'm just trying to
Correct.
get a grasp of what is happening.
Yes. My lord, kindly come to page 15.
Page 15, yes.
This writ
Just,
petition is,
just one.
my,
This is where Paritosh Das.
yes.
Yes.
Same
Same
person,
person, huh? Okay,
same person.
okay.
Please come to the first subparagraph. This writ petition is against order dated 18/5/17 passed by the Commissioner GMC in a representation submitted by the petitioner on 7/1/17 before the additional chief secretary to the government of Assam Guwahati Development Department, which was subsequently forwarded to the Commissioner GMC for necessary action. The private respondent number 8, that is we, on 12/7/16 made a specific complaint to the commissioner that petitioner had undertaken unauthorized construction over a plot of land covered by DAG number so and so, so and so, so and so. On the basis of the said complaint, notice was issued to the petitioner directing him to produce the NOC and approved plan in respect of the alleged unauthorized construction. Though the petitioner took time initially, but finally on so and so submitted his reply, thereby stating his occupation over the land. But the petitioner failed to produce the NOC and the approved plan in respect of the alleged unauthorized construction. Then my lord, may kindly come to the last subpara. In pursuance to the order of this court, Mr. Goswami had obtained necessary instructions from the report of the circle officer, which was received by the zonal engineer GMC, leaving aside 189 and 4717. The rest of the land are covered by DAG number so and so are government land. In fact, dispute is with regard to DAG number 189. An unregistered sale deed was also submitted to GMC by petitioner Paritosh Das, purportedly executed by respondent number 8, which shows that the land covered therein falls under DAG number so and so cycle. Saikia referring to an additional affidavit filed by the respondent number 1 pointed out. In the field inquiry report in TS number so-and-so pending in the court of so-and-so, it would not be out of place to mention herein that this particular suit was filed by respondent number 8 for ejectment of the petitioner under the Rent Control Act. As per the said inquiry report, land measuring 1 kata, 1 desa covered by that number so-and-so is under possession of the petitioner. Land measuring 1 biga so-and-so covered by so-and-so is under possession of the respondent number 8. This suit has been instituted by us, my lord, before the trial court. Then my lord may kindly come to the last subpara. On perusal of the plaint in TS so-and-so, the schedule of the shoot premises consists of thatched house over land measuring 1 kata of the
Mr.
land.
Goswami, just, I'm sorry, Mr. Chaudhary.
My lord.
Mr. Goswami, if he's the institution, respondent number 8 had instituted 22 of 2013,
Yes.
he has to be implemented.
Yes.
Lordship.
I'll allow that
Yes.
application. That is the only fact.
Yes.
I missed out this sequence. Heard. Mr. K. Chaudhary, Senior Counsel, assisted by Mr. R.J. Das, non-counsel for the applicant. Also heard Mr. R. Goswami, Leonard, counsel for the opposite party. Number 1. Next paragraph. No, you'll be respond number
But
4.
4.
For
Respondent
one, for opposite party number 1, Mr. K. Gogoi, additional senior government advocate. And for 2 and 3, Mr. Asbara, attorney counsel. Next para. At the outset, the learned counsel for the opposite party number 4 prays for some more time to obtain instructions. It is submitted that the opposite party is a senior citizen aged about 73 years and he could not be contacted. Next para. By filing this interlocutory application under the applicant, who is the plaintiff in TS number 22 of 2013, has prayed for being included as respondent number 4 in the connected writ petition. So it is submitted that in a previous round of writ petition being WPC 3390/2017, which was instituted by the petitioner, the applicant was arrayed as respondent number 8. And in the order dated 1/2/2021 passed into said petition, a reference is made to pendency of title suit number 22 of 2013, which was instituted by the applicant herein, who was the respondent number 8 in the said petition. Full stop. Next paragraph. Under such circumstances, notwithstanding that the learned counsel for the opposite party number 4 had submitted that the applicant is a rank outsider and has no connection with the subject matter of the writ petition. The court is of the considered opinion that as the applicant has been able to demonstrate that in respect of the construction made by the opposite party number 4, the petitioner had approached the civil court by filing TS 22 of 2013, which was then pending before the Court of Learned Munsif number 2, Kamrup Metro, Guwahati. The applicant has a right to be has been able to demonstrate the right to be implemented as respondent number 4 in the connected writ petition. Puspa. Therefore, comma, the prayer for adjournment made by the London Council for the opposite party number 4 is refused as the right of the applicant has been demonstrated. Accordingly, this interlocutory application stands allowed. And then in the writ petition, you write, in view of the order passed today in so and so, the opposite applicant in so and so is treated as respondent for in the connected writ petition. Notice is issued on newly implemented respondent for to respond to this writ petition. Notice is made determined in 4 weeks. List accordingly.
Why don't I give a
Oh,
date
yes, sir.
after, there's a stay order operating, madam.
You make a mention because
No,
I'm
okay,
I'm at a
My lord,
what
I'll
you
do
call
that.
lot of difficulties managing.
No,
the road. Make a mention, ask.
Certainly.
Give a copy of the writ petition. I think you have a copy.
We have it.
You have a copy. Okay.
The stay order may continue.
Okay. The
Till the
interim order
next
passed
date of
earlier,
listing, madam.
is extended to the next date of listing.
Publish.
Yes. Okay. We have to extend the interim order.
My lord, I was directed to
Huh.
have instruction, my lord.
Huh.
As for instruction, my lord, this is a lane under, which was settled under MNP program, my lord, minimum need program. And therefore, it cannot be sold out, man.
It cannot be sold out. So
It was land given on, settlement, man, by government. Under
Okay.
minimum needs program.
okay, what is the date of such allotment?
Date of allotment is not with me, my lord. If necessary, I can furnish, I can file a
Okay.
detail affidavit, my lord.
Okay, but we'll extend the interim production till the next date. Interim production is there, not to take coercive step.
If it is there, man.
For Mr. M. Mahmood, counsel for the petitioners. Also heard Mr. S. R. Raval and standing counsel for BTR appearing for respondent numbers. Petitioners, yes. For 2, 3, 5, 6, 7. And Ms. G. S. Arikal and government advocate, sorry, for revenue department, appearing for respondent number 1. And Mr. K. Goel and an additional senior government advocate appearing for respondent number 4. 4 and 5. No, this is additional deputy commissioner revenue. I think revenue will come to BTC.
Yes, my lord, it is.
It will come
All
to BTC.
revenue, land and revenue is under BTC.
BTC. So you'll be only for 4. And Mr. BK Sen Leonard. Council for respondent number. Your first 8 and 9.
8 and
8 and 9. Next paragraph. The learned standing counsel for the BTC as well as private respondents raised for and granted time to file affidavit in opposition in the matter. List after the ensuing summer vacation. The interim order passed on the past earlier stands extended to the next date of listing.
But in fact, the land was settled with us way back in the year 1955. I'll satisfy Miller and she.
Huh. No, no, if you're ready for arguing, I'm ready to listen.
No, no, my lord.
Huh.
I'll file it.
It's okay.
Lordship, in this matter, Mr. D. Gogoi was appearing.
Just a moment. You're the owner of track. You're the owner of track. Okay, he'll come.
No, he is not available today due to some personal difficulties.
While disposing appeal, my lord. In fact, my lord, the appeal was dismissed. But one observation that still I can prefer a petition before the concerned authority. But my lord, this, although we file, my lord, nothing has come out.
No, that's not the issue. In this forest offenses, there are two types of confiscation. One is pendency during the pendency of trial, and other is final confiscation order after the trial. Therefore, I'll have to hear him. But this is a 22 matter. Next time, tell him that we'll have to hear it. If he's unable to argue, then he'll have to guide you. Both sides are duly represented. On the ground that due to some personal inconvenience, Mr. D. Gogoi is standing counsel for the
Forest Department.
sorry, D. Gogoi would not be able to argue today. The matter stands adjourned today. Next para, as next para. As the affidavit in opposition has not been filed by the respondents, on the next date of listing, the learned standing counsel for the forest department shall be ready with the case records. Next para, the learned. Your name?
S. Ahmed.
Ms. S. Ahmed, learned counsel appearing on behalf of the learned standing counsel for the forest department shall send a downloaded copy of this order to the authorities to bring this to their notice for production of records. Please start a vacation. I'm not giving a date because immediately after vacation,
Yes.
it's very difficult to manage.
Yes.
Deeply obliged. May it please your lordship. The main arguing counsel is not present here. However, I would like to take the leave of your lordship to present the gist of the matter in this case.
You're ready with the matter?
Yes.
Okay, yes.
Your lordship, I am the sole proprietor of MS Bindu Bhusan Banik. I am a registered contractor. I am involved in executing works contract
And I have the service tax registration number bearing ACNPB 3990RST001. Your Lordship, I was issued with a demand come show cause notice dated 11th February 2019. Wherein the respondent number 4 demanded payment of 49 lakhs 81,930 with alleging that I had failed to obtain service tax registration. And also that I had failed to submit periodical service tax return ST3 forms from the financial year 2013 to 14 up to June 2017. However, Your Lordship, I would like to place it on record that I have been submitting the ST3 forms periodically every quarter.
Where is that?
Your Lordship, I have annexed some of the ST3 forms. Your Lordship may produce.
No, you see, it's a simple issue.
Yes, Your
You have
Lordship.
been issued a show cause notice.
Yes, Your Lordship.
In response to the show cause notice, you'll have to appear before the authorities and satisfy them. Because at
Yes.
this moment, no rights have been affected, no adverse orders have been passed against you.
Your Lordship, the problem with the show cause notice is that the allegations that have been levied against me, as per the reverse charge tax which was introduced in 2012 and which was subsequently amended in the year 2016. So the services which I render, it falls under the manpower supply services. And as
No,
per
I understand. You see, you may be wrongly given a show cause notice. But can it be quashed without what you call without you being required to comply with the direction? Because that is the work which a assessing officer has to do. He has come to a conclusion that you have not given him the required documents.
yes,
Now
Your-
according to you, you have given it to them. So why not present your case before the authorities and have it disposed of there?
Your Lordship, the problem with their response was that they had given very little time and it was done during the peak of COVID period, because of which we were.
No, now
unable
you
to
have sufficient
prepare.
time. This is a 22 petition. If because for that reason the matter is pending. With the show cause notice, we are not doing the job of a assessing officer to hear the show cause notice and then pass an order. But that is something which the competent authority has to do once a show cause notice is issued.
Your
In a
Lord-
tax matter, we are not substituting our wisdom with that of the assessing officer.
Your Lordship, if you may produce some of the, there are other notices which were.
It's okay,
issued.
we'll take your word for it. That everything written in the show cause notice is wrong. But is it a case of violation of any fundamental right to entertain the writ petition? Because you see, whatever you are telling us can also be agitated before the assessing officer when he's issued a show cause notice. There are judgments of this court as well as Supreme Court of India saying that at the stage of show cause notices in tax matter, we should not entertain the writ petitions. It may be grossly illegal. We take a word for it. We are not questioning you that it is hopelessly illegal. But still, it is the tax authorities. The question of revenue is there. They will have to satisfy themselves. So even if you have a good case, still we are not substituting ourselves to be the assessing officers and find out whether the show cause notice itself was right or wrong. Unless you can show me an authority where it says that show cause notices should be adjudicated by the court. Unless you show me an authority on that point. Show cause notice normally should not be interfered with.
Your Lordship, I understand. I require some time from your end, Your Lordship, to place on record in support of my case.
But that doesn't take us anywhere. Doesn't take us anywhere, except for that, even after, let us say we sit over it for 5 years. Even after that, you'll have to go there at one point of time. What is the Supreme Court judgment says that no interference at the show cause notice stage?
I have coming on judgment of this honorable court. It was passed on 20th of 9/2022. Same issue, the notice was issued, they approached this honorable court. And that point was that the pre-consultation for issuing notice was not given opportunity to them. In that one judgment is the record of. Not the notice is of 2019.
This is great ship. Yes. This is Supreme Court.
Yes.
Great ship.
Great. There is another judgment of this honorable court also.
No, not this. This is not a show cause notice.
No, this is not so, not.
No, no, there is a specific judgment of show cause notice, not to.
Today I have not known that. And Lordship, please to see the facts of the case. Second notice, Sanjeev Das, it is a case relating to Sokos notice.
This is show cause notice.
Yes, Lordship, by our High Court. That Uttar judgment 2012 laws.
So accepting our argument will give you, say, 1 month's time to, from today to agitate your grievance before the, you give a reply, show cause reply to the authorities, and will provide that you will be heard in person or online.
Your lordship.
You have online hearing facilities in your department?
Yes, Lordship, that is there. Once they will submit reply, Lordship.
They had,
that
we had
opportunity will be
submitted a
given.
reply, your lordship, on 28th September 2020. Where we had argued the
If you-
allegations.
If you are satisfied with that, it's okay. Otherwise, if you want an additional show cause reply to be filed, we give you that liberty also. Right, but you'll have to, we will relegate you there.
And Lordship, another facts of this case, the notice was issued on 11/2/2019. Thereafter, on 11/2/2022. The opportunity, personal hearing against Sokos notice was issued today. Lordship, they approached this honorable court by writ petition 4356/2021.
Where is that?
Lordship, page 65.
65.
It was withdrawn.
That was some defect in the writ
Yes,
petition.
that was withdrawn. Then again, this writ petition was filed. And
It's okay, we send her back without adjudicating
Yes,
the. EMS S. Prasad,
I'm appearing on behalf of S. Prasad.
your
P.
name?
Dasgupta. My name is P. Dasgupta.
P. Dasgupta. Ms. P. Dasgupta, and I'm counsel appearing on behalf of Ms. S. Prasad, counsel for the petitioner. Also had Mr. S.C. Kyal and a standing counsel for the GST appearing for all the respondents. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, comma, the petitioner has challenged the legality of the demand cum show cause notice dated 11/2/2019 issued by the Assistant Commissioner, GST Tinsukia Division. There are two demand notice.
No, it's a one, 2019.
Page
Subsequent notices were
page
received.
58.
No, she in the rate petition, I am coming to page 12. In page 12, she is referred to one show cause notice and another notice dated 24/9/2020. What is this then? Oh, this is personal hearing. No,
Personal hearing.
no.
No, 24/9. It's
What is
not a
that?
Personal hearing. Your lordship, there is a discrepancy in the
24.
amount stated for the service tax returns. In fact, the amount that they had quoted,
Oh, 6 rupees. 6 rupees. Okay.
in fact, we had paid in excess to that. We had paid
No, it's okay.
29,000.
Oh, whatever be, but 6 rupees difference. That is notice. Okay, and subsequent notice dated 24/9/2020 issued by the superintendent within bracket A/E bracket close oblique CGST, as well as notice for personal hearing dated 11/2/2022 issued by the superintendent, CGST, Digboi range. Next para. In brief, the case of the petitioner is that he is the sole proprietor of a firm under the name and style of Messrs. Bindu BINDU Bhushan BHUSAN Banik, registered contractor who is involved in executing works contract, having service tax registration number. This you will get it in this synopsis. The number is a long number. Like full stop. By the impugned demand come show cause notice dated 11/2/2019, a demand of rupees 49,81,930 was raised against the petitioner on the ground that the petitioner had failed to obtain service tax registration and had failed to submit periodical ST-3 return from financial year 2013-14 to 2016-17, i.e., for a period from October, 2013 to June 2017. Oh, no, sorry. It will be March 2014. Oh, something is wrong. It is from 13 to 17. What is the bifurcated period? 2013 to 17
2013
to 17.
2017.
Or then same October 2013 to June 2017. To stop on the ground that next para on the ground that that no unpaid service tax dues is payable by the petitioner for the concerned period, and on the ground that the manpower supply services which is provided by the petitioner is included in the negative list of service tax right notification number 25/2012-ST dated 20/6/2012. The petitioner is exempted from paying any service tax in respect of the services rendered by them. Next paragraph. The learned counsel for the petitioner has submitted that at the time when the notices were served So show cause notice was served, COVID pandemic was prevailing in the country. First of all, it is submitted that although show cause reply was filed on, where is that?
No reply is filed.
She said she's filed.
No, sir.
It's okay. She's making a statement.
Page number 63, your lordship.
53. Just give me
63, your lordship.
63.
63. It's dated 28 September 2020. 28 September 2020.
Show cause reply by speed post. Dated, reply dated 28/9/2020 by speed post. Which was not considered and notice of personal hearing was issued. And therefore, the present petition has been filed to challenge the arbitrary and improper action of the respondents in issuing the demand cum show cause notice. Next para. Having heard the learned counsel for the petitioner as well as the learned standing counsel for the respondents, even if it is assumed that the contention of the petitioner is correct, yet the court finds that the power to issue show cause notice is exercised by the authority as per statutory power conferred on the respondent authorities under section 73 of the Finance Act, 1994. Therefore, although the petitioner may have a good defense, the same must be agitated before the concerned authority who has issued the show cause notice, as the court has no way to hold that the show cause notice was without jurisdiction. Next, the court cannot presume that the respondent authorities would not consider the show cause reply submitted by the petitioner, or would not consider the argument advanced by the petitioner in the personal hearing. Under such circumstances, court is of the considered opinion that it would be in the interest of justice that the petitioner be delegated to approach the adjudicating authority who's issued the show cause notice in order to protect the interest of the petitioner, it is provided that in the event the petitioner desires to file an additional show cause reply, the authorities will permit the petitioner to do so, and the respondent authorities shall, while adjudicating the show cause notice, shall provide an opportunity of personal hearing to the petitioner, either physically or through online mode, or through authorized legal representative. In view of the discussions above, the court is inclined to close this petition with liberty to the petitioner to appear before the adjudicating authority, I, who is that authority?
Assistant Commissioner.
This is I, the Assistant Commissioner, comma, CGST, Tinsukia Division, within 31/8/2023, with liberty to file additional show cause reply if so desired. And on such appearance, the said in front of that Assistant Commissioner, so Tinsukia Division, just write within bracket, respondent number 4. On appearance of the petitioner, comma, the respondent number 4 shall fix a date of personal hearing and grant an opportunity of hearing to the petitioner. Full stop. Next part, the petitioner is permitted to produce a certified copy of this order before respondent 2 to bring the order to the notice of the said authority. Full stop. With the body as indicated above, this petition stands disposed of.
Fixing 31/7.
31/8.
31/8.
This is, oh no, sorry, 31/7 it should be. 30 days, 31/7, not 31/8.
Much of.
Stop.
Right, Lordship.
Take back your cases.
Lots. Thank you, Harry.
Yes, Mr. Rahman.
My lord. Basis Wilson, my lord. I am speaking, my lord.
Yes, area that.
Area and.
Yes, Mr. Barwa.
In fact, this is not an area rent. They have been claiming all through, but we have filed our affidavit. So, in fact, they are based on an unregistered agreement. That agreement has expired from 1st of May to 2017 and to 31st of April 2020. So, in that particular period of time, his rent has been fixed at 38,000. That has been regularly paid.
Then we'll ask the authorities.
Yes. After that,
No,
since
no.
it is a government establishment,
no.
so we have to have the
No.
TSS.
In that event,
Hmm.
we'll direct the authorities to prosecute the persons who had entered into unregistered agreement. Is it not?
That is one part. That is one part. But here his claim is that he is claiming that area rent from a date which has where he has accepted it readily without any objection. For that matter, we have already written to that PWD because ultimately the rent, the assessment of the rent has to be done by the PWD from time to time. And that communication has gone in, but that till now I don't find anything coming from the PWD side. So unless and until they give a nod to the fresh enhanced rate, we cannot pay. And that part, the petitioner is no longer, we are not in possession of his premises. It has already been vacated long time back. That is one part. And till the time we are in possession, all the rent has been paid, but he's claiming a rent from a period where sanction hasn't been approved or accepted from the PWD, which is a mandatory
Show me the agreement. Show me the agreement first.
agreement.
Because in your submission, you highlighted the unregistered agreement.
Hmm.
Because if a government official enters into a
Please, 18, my lord.
page 18. Now, he's asking rent from when?
From, my lord, 1st May 2020 to 31st December 2022, my lord.
From
1st May 2020
1st May 2020.
to 31st December 2022.
Where is that? Where is that?
My lord, at page 15, my lord.
Page?
Page 15, at the airport. And they have.
No. Show me the document by which you are
My lord,
demanding.
Can you turn to my lord, page 22, my lord.
22.
Yes.
enhanced rent with 1st April 2019. But then, Mr. Rahman, we'll have to relegate you to the civil court.
And then, my lord, they have, my lord, written letter, my lord.
No, because this is something, Mr. Rahman, we can't do anything about it. It's not the rent which you are demanding. What you are demanding is essentially a refixation of rent, which can only be done under the, what you call, fixation of fair rent under the, what you call the rent laws.
And,
In
my
the
lord,
High Court 226, we can't adjudicate that.
yes, my lord, they have written my letters at page 29, can you see page
No,
29?
but what is the issue? Issue is enhanced rent.
My lord,
High Court will not do it.
they have, my lord, written many letters, my lord, regarding enhancement laws, and my lord, they have.
No, I understand. We can give you liberty to write 1,000 letters. Arabian Nights. 1001 stories.
And lastly, my lord, if your lordship see page 33, my lord. Page 33, my lord.
No, you see, representation doesn't mean anything in
It's
fixation
not,
of rent.
it's not representation, my lord. It's a letter written to me, my lord, by the pollution control
No,
department.
but what will be the, what is the High Court which will be adjudicating? What will I adjudicate?
And see page 33, my lord. Page 33.
Page 33. Correct.
The new rent, my lord. The new mutual agreement shall be made effective for the month of May 2022. Yeah, later, my lord.
Yes. Mr. Rahman doesn't take me anywhere. You see, it's ultimately a government what you call a organization. There must be an agreement. A letter, that is okay, but this agreement has to be made. It says a new rent upon mutual agreement shall be made effective. If there is no agreement, how can the High Court direct that this letter becomes a acknowledgement and then you make payment? That would be original, what you call adjudication. The High Court would have no jurisdiction to do it.
On the basis of this letter, my lord, my litigation may be disposed of, my lord.
Unless I arrive at a finding. You see, it's very easy. Every case I can dispose it of by saying that consider the representation.
Not representation, my lord. It is not representation. It is later
Oh,
written
I
by the
understand.
government officials. my lord.
I understand, but if that is the easy solution, it could have been done. Fixation of rent, number one, the High Court, power of the High Court, that is number one. Second is that this letter, it says the new rent upon mutual agreement. It is subjective. Unless there is an agreement, this letter doesn't carry a meaning. And it is only the civil court which can come and say that, well, there's a decree for you to enter into that agreement. High Court in a writ petition adjudicating under 226, can it direct anyone to enter into an agreement, rent agreement?
No, my lord.
Then that's why I'm saying it doesn't take me anywhere. You'll have to show me the road. I am ready to travel, but you'll have to show me the road.
My lord, I understand, my lord.
And he is no longer in possession. So therefore, the only remedy left to you will be to approach the civil court unless you show me any authority which says that this disputes the High Court can adjudicate. I will close this with liberty to you to approach the civil court. But Mr. SSS Rahman, current counsel for the petitioner, as well as Mr. S. Barwar, and standing counsel for the pollution control board, representing respondent numbers 1 to 6. And Mr. D. Gogoi, Leonard, standing counsel for the PWD, representing respondent number 7. Next para.
Respondent
By-
numbers, respondent number 1, forest C appears.
For forest, you are there. Okay. Miss
Yes, Hemant,
S. Ahmed, counsel appearing on behalf of
Forest Department.
the forest department representing respondent number 1. Her name will come first. Her name will come first, number 1, then 2, 3, 4. Next, by filing this writ petition on Article 226 of the Constitution of India, the petitioner is seeking a direction upon the respondent authorities for making payment of a sum of rupees 9,96,384 as area enhanced rent for the period of 1/5/2020 TO2 31/12/2022. First one. In brief, the case of the petitioner is that he is an owner of RCC ground plus 1-storied RCC building, which was let out to the Pollution Control Board Assam. First one, no, not so, wide agreement dated 1/5/2017. For an initial period of 3 years from the date of its commencement. At a monthly rent of rupees 38,000 per month. No, at the provisional rent of rupees 38,000 per month to be assessed and fixed by the Assam PWD Building Division dash Roman capital 1 I Roman Guwahati. Full stop. On it is projected that after expiry of the initial period of tenancy, new tenancy agreement was not executed between the petitioner and the Pollution Control Board Assam. However, the petitioner had requested the Assam, the Pollution Control Board Assam for enhancement of rent as per the assessment made by the Assam PWD. Despite several representations to the Pollution Control Board for enhancing the rent, the same did not yield any result. However, the Pollution Control Board had sought for vacating the tenanted premises on 31/12/2022 without paying the area enhanced rent from 1/5/2020 to 31/12/2022. Next, the learned counsel for the petitioner has referred to contents of letter dated 1/8/2022 issued by the Pollution Control Board Assam to the petitioner, wherein they had agreed to consider rent of rupees 23 per month for the ground floor and rupees 25,000 per month for the first floor. Hence, it is submitted that the letter dated 1/8/2022 being an admission of the respondent, for the Pollution Control Board, direction may be issued to the Pollution Control Board to make payment of the area rent as indicated in the letter dated 1/8/2022. Next para. Upon considering the submissions made by the Learned Counsel for the petition as well as Learned Standing Counsel for the Pollution Control Department. For Pollution Control Board, the court is of the considered opinion that the basic that in order to adjudicate the present the issues raised in the present writ petition and to pass an effectual order, firstly, a direction has to be issued either to direct the to the parties either to enter into a fresh agreement for the period of 1/12/2020. No, this is 1/5/2020 due to 31/12/2022. Or to adjudicate and hold that the letter dated 1/8/2022 is an addition on part of the Pollution Control Board for paying enhanced rent. First of all, both the options available to the court is essentially one which is required to be adjudicated by a civil court and not by the court, constitutional court in exercise of jurisdiction under Article 226 of the Constitution of India. First of all, determination of fair rent either by the PWD or by the court is essentially the jurisdiction is within the jurisdiction of a civil court. First of all, moreover, from the contents of letter dated 1/8/2022, it appears that the member secretary, Pollution Control Board Assam, required that the new rent, upon mutual agreement, shall be made effective from the month of May 2022, the date of reassessment made by the APWD. First of therefore, even the contents of letter dated 1/8/2022 envisages a fresh agreement to be entered into between the parties. First of all, under such circumstances, the court is disinclined to invoke the jurisdiction of this court under Article 226 of the Constitution of India to direct payment of enhanced rent. Full stop. Next paragraph. Nonetheless, the respondents in the pollution control, the respondents, i.e. the Pollution Control Board Assam, being an instrumentality of the state, is not expected to behave like a common litigant, compel landlord from running into court for enhanced rent, which is not desirable, because when a private party is, when a citizen is renting out his property to the state controlled authorities, we also expect a fair play on part of the respondent authorities. Hence, notwithstanding this court is disinclined to invoke its jurisdiction in the matter, comma, it would still be in the interest of justice and fair play that the member secretary, Pollution Control Board of Assam, shall take note of its letter number WB oblique capital G dash 1226 oblique 15 dash 16 oblique 93 oblique 972 dated 1/8/2022 and take appropriate measures to ensure that even without an order of the court, comma, the issue raised by the petitioner is brought to its logical conclusion.
Lordship, if I may, Lordship, the contention stated in my affidavit may also be noted down because there we have made it very clear as regard why he is not entitled for the enhanced period. Page 2, para 6. May I read it for a moment? That with regard to the statement made in paragraph your deponent begs to state that the unregistered rent agreement dated was effective up to 31/5/2022. Hence, the petitioner claimed to enhance the house rents since 1st of
Oh,
April.
then you don't
1st
know how
of
the,
April.
then you have no idea how the PWD behaves. You have absolutely no idea. Either you are living in a what you call ideal world, number one, or in a fool's paradise. You ask Mr. Gogoi, if you give a proposal of enhancement of rent today, how many years it will take to the PWD to give its approval? And in the state government, please take it from me, no financial what you call orders are made for future. These are all post facto approvals which are granted. If you know how the state administration runs, you tell us from your experience, what is the work you do in advance? For tomorrow's rent due, do you think there's a budget proposal today? No, only planned expenditures are, non-planned expenditures are in advance, which includes salaries and all this. For others, all planned expenditures are when the current budget comes.
But
So
if-
either you are, I have said two words. Number one, either you are living in an ideal world or in a fool's paradise. So it is for you to take a choice.
In fact, in the petitioner's case, even though the agreement period is, as your lordship has already gone through twice, 1/5/2017 to 31/5/2020, he has prayed for an enhancement that too in 2020.
Correct, that
for a
is how it is
period
made.
for
That
a
is how it is made.
21 years.
You see, Mr. Barba, if you have some experience in litigation, please tell me that you are a landlord. Put yourself in the shoes of the landlord. Correct? You apply for fair rent before the court under section 5, 3 and 5. Whatever the provisions I forgot. 4. You apply for rent. Now, how many years it takes for a civil court to pass a decree for enhancement of rent? Do you have an idea?
Maybe 3-4 years.
Maybe 3-4 years. And what does the decree say? Your rent enhanced will be from the date you filed a suit.
From the date of filing.
Yes. So it is what? It is prospective. Can you file a suit today to say in 25 my rent will be enhanced? So I am filing a suit now
In
so that
advance.
in advance, so that after 3 or 4 years, I may get a degree in prospective. Can you do it?
Can't be.
So you move the PWD authorities, they will do the inspection, do everything, and then come to it, and then you get an order. So a state can't be unreasonable. Because if you take that plea, then I'll recall my order and I pass orders on merit. I go into the merit. It's your choice. I give you a choice. What do you want?
As your lordship has already passed, I was just trying to.
No, but unreasonable, because then I'll have to enter into the merit. Once you have raised this issue at the bar, and everybody is listening, I have to adjudicate it now. At this stage, the learned standing counsel for the Pollution Control Board has referred to the stand taken in the affidavit in opposition, and it is submitted that the prayer for enhancement of rent was made in the
Page 19, madam,
page,
19.
no, your affidavit in opposition,
Page two.
Page 47.
three.
madam.
page 47, para 6, you said.
Yes.
Whitey's letter dated
Is
25/8/2021 was not relevant. So it is also submitted that the petitioner accepted rent as per agreement dated 1/5/2017 up to the month of August 2021 without any objection. It is also projected that the agreement dated 1/5/2017 had expired on 1/5/2020. And therefore, as prayer for enhancement of rent was made by letter dated 25/8/2021, the area enhancement of rent, the enhancement of rent would only commence prospectively after 25/8/2021. So the set stand taken by the Pollution Control Board has to be deprecated as not acceptable because of the fact that any government institution which is occupying a rental space are required to move the PWD building division for assessment of fair rent, and by the time the adjudication is determination is made, a lot of time, perhaps years go by, as it is not a priority of the PWD to determine a fresh assessment for the fixation of rent. Full stop. Ideally, when the state is a lessee, it should have the Pollution Control Board ought to have expressed his intention to the petitioner not to continue with the lease. Full stop. The said expression having not been made, it would be presumed that the Pollution Control Board would continue with the tenancy. Stop. Under such circumstances, the court is unable to hold that the landlord, public lessor, would have no expectation to have to make a request for enhanced rent. Full stop. It would be a sad next para. It would be a sad day that a citizen of a country would have no faith on the government that unless a prior step is taken, the government would resile from their statutory duty to pay rent. And therefore, if the statement is accepted, it should be a warning to all the citizens in the country not to accept a government as a as an ideal tenant and to visit all government tenancies with suspicion and to take advanced steps which even landlords would not do for an ordinary private tenant. So tenancy agreements are done in good faith and not in bad faith. Full stop. What is more appalling, APPALING, appalling, that the Pollution Control Board, the Regional Office Pollution Control Board, by its letter number APCB oblique ROG oblique capital G dash 23 oblique part PT dash Roman 2 oblique 93 dash 94 oblique 214 dated 10/11/2022 had requested the executive engineer PWD to provide house rent assessment report of the ground floor and first floor separately as per rates prevailing on 1/5/2020 to enable the office to clear the area dues on account of the rent since 1/5/2020. First of having taken that stand in letter dated 10/11/2022, the statement made in para 6 of the affidavit in opposition is quite contrary to the stand taken in the communication to the executive engineer PWD. Full stop. Therefore, ordinarily, next para, ordinarily the court would have relegated the petitioner to move the civil court for enhancement of rent. Full stop. However, in the present case in hand, as the Pollution Control Board Assam has taken a plea which has been deprecated by this court as it relegates the government to a status of a unfaithful or unbelievable institution, the court is of the considered opinion that this is a case which is an exception to the rule of relegating disputed questions of facts to be relegated to be adjudicated and decided by the civil court. Hence, the court is inclined to invoke its jurisdiction under Article 226 of the Constitution of India by issuing a mandamus of the Pollution Control Board Assam to pursue the state PWD to complete the assessment of the fair rent in terms of their letter dated 10/11/2022. Stop. Similarly, the state PWD is also directed to consider the request of the SEE regional officer, Pollution Control Board Assam, paid by letter dated 10/11/2022, referred to above, and determine the fair rent and assess the fair rent, not fair rent, assess the rent payable from 1/5/2020, and the assessment shall be completed within an outer period of 2 months from the date of receipt of a certified copy of this order. Next paragraph. On such assessment being made, the Pollution Control Board Assam shall ensure that the payment due to the petitioner on account of enhanced rent with effect from 1/5/2020 till it has vacated the premises on 31/12/2022 to be paid within a outer limit of 45 days from the date such assessment is made. First off, it is made clear that if the rent is not paid within the time as provided herein before, comma, the area rent shall carry interest at the rate of 12% per annum on and from the date of this order till such payment is released. Reflection stands allowed.
Well, also, this is for within 45 days from the. From
You
the
do it within
assessment.
2 months and you'll do it within that day.
Yes.
Failing which, if they don't do it, you pay
Yes,
interest.
No, in fact, board is ready, but.
And
we are
you see, you have compelled me to use that the state government is
waiting.
unbelievable, unfaithful,
I'm so sorry.
and doubtful. No, that can't be. As the government, which is my government,
In fact, the board was very much willing to pay, but finally,
No,
since
but
he
this-
was claiming for
you
a
see,
period, his
how this stand has changed me. I was relegating you to the civil court and this submission turned me. Because I can't hold my government to be unfaithful.
in fact, it will have a casting effect.
It will have.
It will have a casting effect. If
It will
if at
have.
all lordship just tries
It will
to
have because I can't-
modify a bit. Because ultimately I will be affected.
No, no.
My intention
No,
was
no.
never, because I was trying to
No, no.
assist the court as regard the days
No,
from
but
which
that-
he was
that-
trying to.
that is a submission we can't accept. What happens
My
to,
submission is supported by my
What-
affidavit. in fact.
what happens to the ordinary litigant? Will they, what you call, look at the government with suspicion? That is the worst day for a citizen and a country.
In fact, my humble apology, if at all it is my mistake, then lordship may kindly.
No, it's not a question of mistake, it's a question of stand. You have taken the stand which is there, the
Stand,
authorities, and that I have
that
respected with it.
authority has taken that stand, in fact,
No,
but
no.
that may
Mhm.
kindly be modified for a month,
No,
if at all.
Mr. Rahman now requires a court assistance, because if
Because
does not have-
although,
if he does
although,
not have faith on the government, to whom will he go?
no,
he is only got-
lordship, because from all the representations, lordship can very well find out that board was very much willing to give, provided we have an.
No, it's okay, it's okay. I have
sanctioning-
taken a decision, it's all, it's over. 36. Yes. Arbitration proceeding 36.
It is the lordship. This matter pertains to appointment of arbitrator.
Yes, Mr. Chaudhary.
In fact, I was required to file my affidavit. His prepared lordship has sent it for signature. If it can be taken up on the reopening lordship.
This is arbitration appointment only.
Yes, sir.
You will
Yeah.
take a standard plea.
The lordship, they wanted to file a. lordship,
Okay.
Let it be on the reopening lordship.
Okay. Mr. B. Bora,
Be brother.
counsel for the petitioner. Just on the prayer made by Mr. R.K.D. Chaudhary, DSGI. Further opportunity of 4 weeks is granted to file affidavit in opposition in the matter. So it is made clear that if affidavit is not filed within the time allowed,
Yes, yes.
the court would hear the matter on the basis of materials available on the court. List after 4 weeks.
Can it date be fixed? lordship?
I'm not fixing a date right now because after vacation, it will be unmanageable. If I give dates.
37.
Lordship, we pray for some time to file affidavit, lordship.
37.
37.
Just a moment, there's something here. Just a moment. Yes, because this is time is running out
Lordship.
in this case, that's
So
why.
lordship may reopening lordship may sometime.
I'll give you a fixed date because there's some urgency.
Lordship.
I'll give you some time. Also, it's duly represented on the prayer made by Mr. K. Gogoi on at CEC. Further, time is granted to file affidavit in opposition in the matter, which will preferably be filed within at least 2 days prior to the next date of this case.
Lordship.
This not out of we will give a date in this case.
Lordship.
28/7, Lordship. Obliged, Lordship.
65.
Just you and Mrs. Bora, just try to have some what you call technical input, because here not only affidavit, but I must understand the technicalities of it.
I will put it also, Lordship, the affidavit filed by the health department before the honorable attached court, Lordship.
No, you have said that. No,
Lordship.
no, not only that,
Lordship.
because here what we will require is
Lordship.
some more education than your affidavit can give, some
Lordship.
literature or something which
Lordship.
you can get it from the authorities so that I can read and understand.
Lordship.
It's highly technical matter.
Lordship.
I have to understand the things.
Lordship. I will do this.
But I am told by the doctors,
Lordship.
I had a casual talk. Doctors say it's still permissible.
Lordship.
Age may not be a factor. That is what the doctors say, but they
Lordship.
have not opined because they are not
Lordship.
specialists in this technique. They are not experts. But I have spoken to a doctor who is now the head of the department of gynecology in a particular state,
Lordship.
a hospital. He says that it is still permissible.
Lordship.
Age may not be a factor. So therefore, some literature.
Lordship. Obliged.
Yes, stone crusher, your matter.
My lord, my stone question unit which is otherwise they have provided with all permissions, my lord, because of the,
Yes. But they have
I
to say
think he
that.
wants to place some.
Here, there is just one aspect of the matter, my colleagues were handling the matter. One aspect of the matter which perhaps was troubling me a little, Your Lordship, is that the stone crusher which was closed, Your Lordship, was pursuant to a direction passed by the Honorable Apex Court. Now, the stand taken by the petitioner is that firstly, notice was not issued to him, Your Lordship. And secondly, that his activity of a stone crusher perhaps does not come within the ambit of other activity as used in the Supreme Court order, Your Lordship. Perhaps that clarification, Your Lordship, if we were to sit in interpretation of that order, perhaps, Your Lordship, perhaps this is a clarification of the Supreme, because this is a continuing mandamus, Your Lordship, in the TN Godavaram matter. The petitioner wants a clarification on that whether the Supreme Court wanted other stone crushers to come within the ambit of the term other activities, Your Lordship. Then the petitioner.
No, because you see that you may make a stand that will interpret.
Lordship.
You see the reason is that number one, there are two factors. Number one, that day also I took up the matter in the eco-sensitive zone.
Lordship.
So there's one area which is eco-sensitive zone, and if the activity is within the buffer area, then these activities are banned under TN Godavarma. There's no issue with that.
Yes.
Now, what you call, but if it is not touching upon the coordinates of the eco-sensitive zone,
Yes, Your Lordship.
then perhaps the activity can't be prevented.
That exercise, Your Lordship, if mine, perhaps, because we specifically asked them whether the location of this particular stone crusher, whether it's touching the coordinates, Your Lordship. That exercise has not yet been done, Your Lordship.
But then also you have to file an affidavit. If it's
Because
Lordship, my
if on
submission may
that,
kindly be considered. Lordship, number of opportunities they have given for filing of affidavit. Lordship, just kindly see the last order, 8/6/2020.
no, you see, they have difficulties. You must understand that also.
Understood.
And
Now,
you see,
Lordship,
the difficulty is that the authorities don't want to move the Supreme Court to have a clarification.
question.
Therefore, once they are not doing it, now we are requiring that this be brought to our notice. We'll adjudicate.
Lordship, page
Ultimately.
57, my lord, there is no demarcation. We'll just look for a moment. Page 57. Under RTI, the information which they have shared is clearly said, my lord.
No. You see, boundary is not the issue. It is a eco-sensitive zone which has been now declared under the TN Godavarman.
Right.
What it is directed is that to create a what you call this eco-sensitive zone.
Absolutely. Quite right.
So
Let me-
if it comes within that eco-sensitive zone,
Absolutely.
it may not touch the boundary.
Absolutely. Even we do not want, my lord, that our activities should be affected.
So therefore we'll have to now adjudicate it.
another aspect would be, Your
Lordship,
Lordship,
may I pray one thing, my lord, that Lordship kindly see that so far the direction is concerned, that direction was given by the Honorable Supreme Court to the police authority that no illegal mining activities and related activities should be carried out. That was the, my lord, direction. Now, pursuant to that, instead of police authority, the police department step in and they took a resolution that because of their just Honorable Supreme Court direction, therefore all stone crushing units to be closed down. My lord. Question is that my lordship rightly pointed out, if it comes within the zone of eco-sensitive, question doesn't arise, my lord, we should not claim anything. But my area so far, my lord, activities which we are running, my lord, we are just, my lord, making piece of stone which we have purchased from TP from other, my lord, areas, my lord, Taviano, etc., which doesn't come anyway in the zone of, my lord.
But the transportation area is same.
But transportation,
You can't move into this, your place, unless you move into the territory of Kaziranga National Park.
my lord, we are not coming from that side, my lord. We
No,
are
I that I don't know. That I don't know, but I have considered that factor.
my lord,
So
absolutely.
therefore, their affidavit is required. Without that, we can't adjudicate and, because the issue is, once there is a direction, somebody is interpreting that this stay is because of the Supreme Court direction.
Right.
Then we have to consider all the factors.
Absolutely, quite right, my lord. Lordship thing is that they are
File your
totally.
affidavit by then.
Yes, sir.
Whatever you think that you pen down your affidavit.
Including the location of the.
No,
Whether-
whatever you, it's,
Yes,
the filing of affidavit is your
Yes,
discretion. You
yes.
do whatever you want.
Yes, sir.
You can give a last chance, my lord, that they have taken a lot of opportunity.
Because you see, now I have some experience in dealing with the orders of the Supreme Court. Where directions are given to have consultation meetings and to take a decision. In 2 or 3 matters, we are doing it. For example, JJBs, they are under constant monitoring of the Supreme Court.
Right.
The second issue is the vulnerable witness deposition centers,
Right,
a
right.
continuous monitoring of the Supreme Court.
My lord.
So therefore, now I have some experience in dealing with these matters. And we also know that the decisions taken there, even now at 4:30, I have been a meeting with the Honorable Supreme Court Judge on one of the matters relating to constant monitoring.
My lord.
And they're thoroughly prepared when they attend these meetings. So any wrong step will invite a very,
My lord, it's very
Uh,
dangerous to all
uh,
concerned.
uh,
It's not a small issue or individual issue, my lord, it's a larger issue.
therefore-
No doubt, my lord. I agree with that. Actually. Only thing is, lordship, can I give a specific direction of filing
Yeah, yeah,
affidavit so that matter could be.
file an affidavit. Ultimately, you'll have to adjudicate.
Yes.
I Mr. S. Chamaria and counsel for the petitioner. And Mr. K.V. Pathak, understanding for the forest department. You have everything for all,
For. No, forest department ultimately party, my lord.
for all the respondents. Next para.
Not for S1 number 2, Your Lordship. That is a subdivisional officer.
And they have no bigger role to play
1,
otherwise.
3 and 4 and
1,
3 and 4.
1, 3 and 4 and Mr. K. Govind and additional senior government advocate appearing for respondent number 2. Next para. On the prayer made by the understanding counsel for the forest department. Last opportunity is 4 weeks is granted to the forest department to file their affidavit in opposition in the matter. Taking note of the fact that the stone crusher of the petitioner has been closed pursuant to their orders. First off, it is made clear that if affidavit in opposition is not filed within the time allowed, the court would proceed to hear the matter on the basis of materials available on record. Next para. Even if no affidavit in opposition is filed, the respondents, the forest department shall produce the map of the eco-sensitive zone close to the
Proposed ecosystem.
proposed eco-sensitive zone close to the establishment of the petitioner, as well as the geo coordinates. What is it called? Geo
Geo coordinates.
coordinates in respect of the establishment of the petitioner. Similarly, the learned counsel for the petitioner shall also produce geo coordinates of the establishment of the petitioner on the next date of listing.
Madam.
Geo coordinate, you'll,
Actually, only not see any date, madam, if possible.
I'm not giving a date, I'll
Fine.
make a mention.
66.
66 lordship, we need sometime, we have written lordship or await for instruction lordship.
Just a moment,
Yes, lordship, inspection lordship, you have recorded the order.
just a moment. But then we'll have to call the officers.
Lordship may, on Friday, lordship may fix it, we'll try lordship. On Friday, lordship may fix it. Lordship.
On the both sides that you represented on the prayer made by Mr. K. Govind on an additional senior government advocate. A last opportunity is granted to the Deputy Commissioner of Police, Guwahati West Police District to produce the relevant records based on which he has passed an order to seal the dump of the petitioner. Pushpa. The Deputy Commissioner of Police, Guwahati West, West Guwahati Police District shall take notice that if without any lawful cause, the documents are not produced, the court may consider non-production as deliberate and willful disobedience of the order of the court, and appropriate action shall be initiated, for which appropriate order will be passed on the next date. Next, the learned additional senior government advocate shall send a downloaded copy of this order to the said authority. Next, for a list on Friday.
Lordship, lordship.
22 to 26.
What is the lordship?
Today I'll be rising early. I may not take up many of the matters. There is a conferencing I have to attend. There's a video conferencing I have to attend. Constant monitoring matter. Yes, this is 23, 26. Okay. Just a moment.
Without any
Just a moment.
notice, without anything, well,
No, just a moment. But your term is already over. Why should we entertain?
But that in such cases, well, that is why I produced 2003 one SC, and thereafter that was followed in 2007 11 SC. This is what you want.
What is that?
Well, page para 35 to 39 job.
No, you won't get the benefit of this judgment.
Well,
There's a simple reason. This dates of mining lease.
well,
The mining lease was for a term of 10 years. Now,
But here, my lord, I have established this kitchen. I
no,
have
maybe,
invested-
but doesn't create a right. You see, because of this here, the lease rights were for 10 years, and therefore you are permitted this. In this case, there was a permission granted to run the lease for 10 years.
Well, there are two types of cases, my lord. In the 2003 one SCC, that was, well, extended for 1 year. But as per the rules, it should be 3 years.
No, but after the expiry of lease, can you be granted extension by the court? I don't think so. You show me that 2003.
That 2003 one SC and this one. These are the two cases, my lord.
2003, I don't have this, 2011, I
Yes.
am having.
Yes, but para 35, my lord, I have, what I am placing, that has been quoted, my lord, para 35.
Para 35
After judgment.
of this judgment. This also doesn't help you. In this case, this page para 35,
Yes.
Begraj Singh case was cited.
Yes,
Here, as per the law, the mining lease should be for a term of 3 years.
Yes.
But in this case, the lease was only for 1 year. And therefore, the Supreme Court says that the lease period you can be given. See para 35.
yes. After expiry, my lord, that was done.
So the court further observed that when the petitioner was wrongfully disallowed to operate
Yes.
for the full lease period, you are given the right to extend till that period. But beyond the period of lease, that is something which is impermissible.
My lord, in this case also, my lord, you can also see, my lord, how.
No, I've seen that. That's why
My lord.
you see this. Because here in this case of 2007-11 SEC,
Yes.
what had happened was that during the currency of the lease,
Yeah.
there was a change in policy. And therefore the Supreme Court says that no, when the policies change during the currency of the lease, you will have to continue with that lease for the remaining period. That is what is held here.
My lord.
It doesn't give you still a right to have an extended term when your original tenure is over.
My lord, what I submit, my lord, that because your lordship has seen the order, my lord, how they have transmitted it.
No, it's okay, but the normal tenure is
Then
over.
not the, my lord, I have established the base kitchen, they have inspected it, everything has been done. After we have taken the rent, the land on rent of 75,000 per month and constructed a base kitchen. And still,
Because you have the right to what you call claim compensation or remission. Or compensation before the Supreme Court, but the power of the rate court to adjudicate this.
till now, my lord, they have not advertised again, my lord.
No, that is okay. Because you see, your main prayer is to revoke the cancellation order. Even if we do it,
Yes,
the period of lease has expired.
that's correct, my lord. That is why only, my lord, I am relying on this, saying that, my lord, since they have cancelled the lease without giving any opportunity to me, my lord. After 10 days, my lord, they have stopped it. And thereafter cancelled it. Only I work for 10 days. my lord.
Now we can still make an observation that it may give you right to approach the civil court.
Arbitration clause is there, my lord.
Arbitration is there. So you invoke that arbitration clause. They permit you to do that.
My lord. Yes, my lord, that is, my lord, your losses were just. My lord, did not need it.
Clause 56.
My lord, it is at page 63, my lord.
63.
Yes.
But Mr. Saivala,
My lord,
you'll have to excuse me, I'll pass orders in the chambers.
my lord,
You'll get it tomorrow only.
no problem, my lord, that is not the, my lord. Only thing I just placing the arbitration clause, my lord.
Huh.
Let's.
Okay, just note, Mr. G. N. Saivala, Senior Counsel, assisted by Mr. KP Upadhyay. KV Upadhyay, Counsel for the Petitioner. And Mr. S. Vora, the Standing Counsel for the SSA. You, for all the respondents,
And there is one from the elementary education,
elementary,
elementary.
who appears for elementary?
Let SMT Chisti's name be reflected.
Hmm?
SMT Chisti's name be reflected, man. SMT Chisti.
SMT Chisti for respondent number 1 and Mr. S. Vora, Standing Counsel for respondent number 2. Okay.
Well,
We will grant you leave to file, to do the needful for appointment of arbitrator, to move the authorities for appointment of arbitrator, correct? That needs no limitation, extension of limitation is required, no,
Yes.
not required. We just say that this writ petition was filed, just make a note. This writ petition was filed on 25/2/2022,
Yes.
and therefore the period spent before this court. In respect to the period spent before this court, the petitioner will be entitled to extension of period of limitation, if there be any, to move.
An earlier period, my lord, is as per Supreme Court judgment, we see it.
No, I can only save this much.
My lord.
Extension limitation. As period spent litigating before this court. So that I lied. No, this is complete. Tell the court master because I don't have time today.
Item number 57, my lord. My farm is already, my lord, shut down for 2 years for non-renewal of the license, my lord. Day after tomorrow.